Board of County Commissioners acts as a quasi-judicial body when it hears requests for rezoning and conditional use permits. Applicants must provide competent, substantial evidence establishing facts or expert witness opinion testimony showing that the request meets the zoning code and comprehensive plan criteria. Opponents must also testify as to facts or provide expert testimony whether they like or dislike a request is not competent evidence. The board must then decide whether the evidence demonstrates consistency and compatibility with the comprehensive plan and the existing rules in the zoning ordinance, property adjacent to the property to be rezoned, and the actual development of the surrounding area. The board cannot consider speculation, non-expert opinion testimony, or poll the audience by asking those in favor or opposed to stand up or raise their hands. If a commissioner has had communications regarding a rezoning or conditional use permit request before the board, the commissioner must disclose the subject of the communication and the identity of the person, group, or entity with whom the communication took place before the board takes action on the request. Likewise, if a commissioner has made a site visit, inspection, or investigation, the commissioner must disclose that fact before the board takes action on the request. Each applicant is allowed a total of 15 minutes to present their request, unless time is extended by majority vote of the board. The applicant may reserve any portion of the 15 minutes for rebuttal. Other speakers are allowed 5 minutes to speak. Speakers may not pass their time to someone else in order to give that person more time to speak.
All right, welcome everyone. We're going to get it called to order here at 5:02. We're going to start out with a moment of silence. Commissioner Snarty? We've got a few things we're going to move around toward the beginning of the agenda, then we'll pick up back on track as listed here. I did hear there was going to be a request to table item H is in Hotel 2. Is that correct, staff?
Yes, sir.
Okay, I don't know if we want to have a motion at this point or if we need to read something into the record as it's quasi-judicial.
I can read that item for the record just to have board acknowledge that table.
Thank you.
So H2 is 19 PZ 00108. Bonnie Douglas requests a change of zoning classification from RU1-9, BU-1, and TR3 to all TR3. The applicant has requested a tabling to the February 6, 2020 BCC meeting.
Thank you, sir. May I have a motion? Okay.
Second.
Sir.
Can we make that for a time certain? February, we're getting a date here.
Yeah, I'm happy. If you want, we can put the time here, or I'll just handle it
6th.
administratively later. That's fine. Okay, so did you get the motion in the second? Okay, so it was Commissioner Isnardi for the motion and Commissioner Pritchett for the second.
For February the 6th?
And it'll be set time certain. I'll work with the applicant to figure out a time that works for them. All right, moving on to some fun stuff, resolutions, awards, and presentations. Before I get to this one particular item, I did notice, and if I miss someone, please jump up and flail around a little, because I don't intend to skip anyone that's here. I want to recognize a few special folks that are in attendance. I believe for this item, I'd be shocked that they were here for something else. I did see several of our judges here in the 18th. I saw Judge Davidson in the back. I saw Judge McLuhan up front, Judge Atkin in the back. Did I miss anyone, judge-wise? If that's a word. And then I also saw some of our former BCBA, our local bar presidents, Brian Onek up in the front with Ashley Hardy, and then Kim Rozenka as well. So thank you all for being here. With that, I'm going to move into item E is in Echo 1. So this item is a resolution recognizing Annette Melnikov, who I do see in the back. Thank you for coming. Reads as follows. Whereas the mission of the A. Max Brewer Memorial Law Library is to collect, preserve, and provide access to legal resources and information for all citizens of Brevard County, and whereas Annette Melnikov served the Brevard County community in the capacity as a law librarian since 1985, offering top-notch historical and legal research coupled with unparalleled customer service, And whereas Annette Melnikov was instrumental during the time period when Brevard County had 3 law libraries, one in Melbourne, one in Rockledge, and one in Titusville, and Annette faithfully served during the consolidation to one law library at the Harry T. and Harriet V. Moore Justice Center here in Vieira. And whereas Annette Melnikov's dedication to the legal community, character, competence, and commitment were recognized by the Brevard County Bar Association by her selection in 1999 as the first recipient of the Professionalism Award in the non-lawyer category. And whereas Annette Melnikov devotedly served as the director of the A. Max Brewer Memorial Law Library since 2005, and whereas Annette Melnikov retired in 2019 from Brevard County after 34 years of dedicated service to Brevard County residents, now therefore be it resolved that the Board of County Commissioners of Brevard County, Florida does hereby recognize and express its sincere gratitude to Annette Melnikov for her dedicated service to the citizens of Brevard County. May I have a motion?
Make a motion to approve, sir.
All right, we've got a motion and a second. You'll have that? All right, all in favor? Aye. Any opposed? All right, unanimously passed. You want to come up and say a few words, Annette? Can I cajole you to do so?
It's been my privilege to serve our Brevard County residents, the government, and members of the court. I'm very honored. Thank you very much.
Thank you so much for being here. I can say as a former bar president here in Brevard, I never had anything but good experiences with you in the years that we worked together. And when I spoke with Ashley, who predated me in that position by a little bit, she had said the same. So, you know, it's rare that we have someone in the legal profession in any capacity where there are no complaints ever. And you are probably the only one that comes to mind. People are upset with their lawyers, they're upset with the judges, but I've never heard a crossword or even a suggestion about you having done anything other than your utmost best.
Thank you.
So thank you. All right, we're going to move items H's in Hotel 5 and 6 up at this point. I did get a request based on some extenuating circumstances from the applicant's counsel. I do have some disclosures to read into the record with respect to that. I do see that, bear with me one moment. You know, if you want to do consent first, or? No, it's up to you. Yeah, that's fine. We'll do consent first. Yeah, we'll go ahead and do consent first. Do we have a motion with respect to consent?
Motion for consent with removal of F2 because it was placed there improperly.
Okay, so I guess in this case, it'll just be F1 in terms of consent.
Correct.
So we've got a motion to approve F1.
Second.
With a second. Any discussion? All in favor?
Aye.
Aye.
Any opposed? All right, carries unanimously. So we'll move on to H5 and 6, and then we'll move on to F2 in a moment. So H5 and 6, I did have some disclosures. And if anyone has disclosures, please just jump in. Don't let me skip anything. I do see a light from Commissioner Tabaya.
Thank you, Mr. Chair. I received an email additionally to the ones that I've pre-disclosed from Mr. Beto on 12/5 stating the belief that the approval of this item would be more than double impact. Thank you, Mr. Chair.
Thank you, sir. Commissioner Isnardi?
And I have that. I have that same disclosure by David Botto of the Marine Resource Council, and he's against the request.
And
Commissioner?
I also have already pre-submitted all of the items that I discussed, except the ones I handed you guys out right before the meeting.
All right, perfect. And I have the same disclosure as was mentioned with respect to Mr. Botto on the 5th And then I have a subsequent one as well, or a second disclosure from Mary Sfar on the same date, expressing concern by email about this particular proposal. So that said, Ms. Rosenka, this is your item, I believe.
Mr. Chairman, if you would allow me to read
Please.
both items into the record.
Yes, sir.
H5 and H6 are companion, so with that, item H5 is 19PZ 00075. Ray L. Cogan requests adoption of a large-scale comprehensive plan amendment to change the future land use designation from residential 1 to residential 2. It's located in District 1, Commissioner Pritchett. Item H6 is 19PZ 00118. Ray L. Cogan requests a change of zoning classification from AU to RU 1-7 with a BDP limited to 2 units per acre. It's located in District 1, Commissioner Pritchett. Thank you.
Thank you, sir. Ms. Rosenka.
Thank you. Good evening, Chairman Lober, members of the County Commission. My name is Kim Rosenka. I'm with the law firm of Cantwell and Goldman in Cocoa, Florida. I'm here on behalf of Beachland Managers, LLC, represented by Chad Giannoni. This is a rezoning and comp plan amendment for Ray Colgan on a very narrow strip of land that is 52.53 acres on State Road 520. This came before you for the comprehensive plan amendment on September 5th of 2019 for transmittal. It was approved unanimously. It was sent up to DEO. Comments came back from all the agencies. None of the agencies had any comments of any substance. So it's now before you for adoption. Nothing has changed since I was here on September 5th. This is also for a rezoning to RU17 with a binding development plan to make it compatible with the residential 2 rezoning request. This is a long, skinny piece of land, as I stated. It's about 332 feet wide. It has had the same configuration since at least 1990. There's been very little development near this property or in the area. There are a few homes. Most of them are modular homes or trailers, and that's because it's hard to develop out there because there's no roads. Also, too, there was no sewer or water or drainage in this area. It was a 2-lane road for many years, so circumstances have changed substantially to make this now more developable. The property around the area are Res 1, but to the south is all residential 2. Also, if you go 2 parcels to the east, there's a pending PUD zoning in the city of Cocoa for 50-foot lots, just to give you a perspective of things that are moving and things that are developing in the area. In fact, the map that was in your packet that I submitted to Planning and Zoning shows 3 other developments in the area that are all small lots, 50-foot lots, because in this area, that seems to be what is desirable, and that's what the market is demanding. There are public facilities and services are available out to this property now. A school capacity exists. The staff concluded that this flue change would not cause a deficiency of adopted levels of service, and that the comprehensive plan analysis, it meets policies 1.8A and 1.2. It also meets the comp plan amendments I've discussed in the past of giving a variety of housing units. There are not a lot of housing units out here that are new and of this size, except for what's been being developed. As to the rezoning, again, the rezoning is being asked for RU17 to allow the design of this property so it can be used for homes. The BDP would limit the units to 105 units at Res 2. The only issues I was aware of is issues raised by the owner of Sterling Stables, which is immediately adjacent to this property, and that was at planning and zoning at the transmittal stage. And he was concerned, he had no problems with the rezoning or the comp plan. He was just concerned about environmental constraints on the property, which Mr. Giannoni has spoken to him and is going to resolve and help Mr. Gary Dana. As to that, there were an issue from others regarding stormwater. As you know, that will be determined during site plan, and that there is no way it can impact others. They have to maintain the historical drainage patterns. So with that, I would ask approval of the Comprehensive Plan Amendment 2019-2.1 from Res 1 to Res 2, and the zoning change to RU17 with the binding development plan.
Thank you. And I presume you want to reserve the remainder of the time for rebuttal?
Yes, sir.
Okay.
I just thought there might be questions.
Please.
Ms. Rosanka, I think the homes around there they're moving from septic over to sewer right now.
Yes.
Is that going to be an availability, or are we going to have a little bit of time? I think there's probably plenty of space to go ahead and put in septic.
With
but-
those size lots, I don't believe they're allowed to have septic with those size lots.
Okay.
And the development I've discussed in Cocoa is bringing sewer all the way.
You're having sewer.
Yeah, it's my
Okay.
understanding he's going to bring sewer out there because of the size of the lots.
Okay, thank you.
Great, any further questions for the applicant? Okay, seeing none, we've got a couple public comment cards. First off, we have Mary Spar. And I'll just save her the effort here. She's in Cocoa, Florida, so we've got her name and we've got her city.
Good evening. I put in a card for both those, so I'm not sure how much time I get. Hopefully I finish what I have to say. Mary Spar, I live in Cocoa. I stumbled across this comp plan amendment and associated rezoning request for a density increase when I was looking for your agenda item for the MICO item, which is coming up. This property is a little west on 520 from our neighborhood, but like our neighborhood, near the St. Johns River at Lake Poinsett. The issues on this property are complex, and you need to take the time to make the right decision for any future homeowners of this property and for the health of the St. Johns River to which the property drains. The comp plan amendment adoption decision does not need to be made tonight. The state of Florida only requires that the adoption hearing take place within 180 days of receipt of agency comments, and that would put the deadline around the middle of April. This property has problems, the extent of which are not readily known. The problems result from the use of the site to process and spread septage, which is septic tank pump out. This activity occurred over 20 to 30 years. The problems include illegal wetland damage that needs to be addressed. Furthermore, the site needs to be evaluated to determine whether any health risks remain on the site. Finally, there is no stipulation in the BDP to connect to sewer. According to your staff report, the current site owner has been processing septic tank waste with lime and spreading the resulting biosolids on the property for approximately 20 to 30 years. Biosolids have been deposited in on-site wetlands. St. Johns River Water Management District determined that impacts to 2 of the wetlands were unpermitted and will require restoration or mitigation for the loss of wetland function. Staff then notes that Brevard County ordinance requires that the situation be fixed. The language staff is referring to states, both in the ordinance and comp plan, quote, if an activity is undertaken which degrades or destroys a functional wetland, the person authorizing or performing such an activity shall be responsible for repairing and maintaining the wetland. In the event it is not feasible or desirable for the responsible person to perform the repair and maintenance of the wetland, then the responsible person shall mitigate for the wetland loss. The staff report then states, however, it is unknown at this time the amount of wetlands that may be mitigated and the amount that will be required to be restored. Before any density changes are granted, we would like the damage resulting from the unpermitted wetland impacts to be fixed. We would also like the property to be evaluated for health concerns and cleaned up as appropriate. On another subject, septic or sewer, we realize that the applicant is claiming this will be worked out at the site plan level. That is too late since Brevard County does not outlaw new subdivisions on septic. Septic is inappropriate on this property. Actually, the property owner told DEP in an email dated December 2nd, 2017, quote, the phosphates were too high in field 1, but the hurricane put me under 2 feet of water. That should tell you the property is not a good place for septic. Yet the applicant told the LPA transmittal hearing on August 19th he was planning on septic but was not totally sure. From the P&Z LPA minutes, quote, Ron Barcher asked if Mr. Giannoni said he would or would not connect to sewer. Mr. Giannoni replied, at this point, he is not 100% sure if they are going to connect to sewer. He said originally they were planning on septic tanks, but they were hoping to get through to the zoning phase to determine what it would be allowed. The applicant's attorney noted at the LPA adoption hearing that there is sewer availability. If that's the case, why not put in the BDP a stipulation for connection to sewer? You may want to ask about the details of where the nearest sewer connection point is.
Ms. Farr, hang on one sec if you would. Ms. Bentley, in terms of folks that submit for 2 items on the same time card, is the best practice in your estimation to double the time and just permit that, or how would you suggest we handle it?
You can do that, but you can just let them make the presentation, and if they need additional time to reach the 10 minutes, they would be allowed 10 minutes.
Okay, I'll go ahead and give you up to 10
I've been going
then.
pretty fast, but
Sure, no, it's
I'm
okay.
in the last paragraph.
Sure, please.
Okay. Yeah, I agree. It's good to set that policy because I was a little nervous. Okay, so my husband will speak on the health aspects and questions concerning this property. In conclusion, please make sure the wetlands are cleaned up before deciding whether to increase density with the comp plan amendment and rezoning request. Also make sure that any future subdivision on this property connects to sewer. You have time to make the right decision. Please take advantage of it. Thank you.
Thank you. All right, next up we have Douglas Farr, also in Cocoa.
Good evening. Again, Douglas Barr, 825 Clifton Cove Court, Cocoa. And with Mary, I'm a longtime property owner and resident on the St. Johns River west of Cocoa, not too far from this property. Given the long history of the use, by the way, I'm speaking on both items. Given the long history of the use of this property, there should be no residential development permitted until the property is cleaned up and health concerns allayed. According to a query I made to DEP, Circle C has engaged in land spreading of septic tank pump out since the early 1990s. I handed you a Google Earth photo, the earliest I can find from 1994, showing the property in full operation and appearing much as it does in the recent photo in the staff package. At Circle C, septic pump out trucks drove in and offloaded septic into a large tank where the septic was mixed with lime. The purpose of this so-called lime stabilization is to help prevent vectors. Vectors is an EPA term that includes rats, birds, and flies that could carry pathogens off-site, and to slow down the propagation of pathogens. But this lime stabilization does not sterilize the septic. After being stabilized, the septic is carted out and spread out upon the property. And this has been going on for, as I said, somewhere around 30 years. So long, it even challenged the DEP people to find out how far back it did go. Over the years, Circle C has operated under various Department of Health permits that allowed the spreading of up to 10,000 gallons per day. And I might mention for over 10,000 gallons a day, if DEP takes over the permitting of septic. The Florida legislature decided to ban the land spreading of septic and enacted Florida Statute 381.0065, parentheses 6, that banned land application of septic effective January 1, 2016. Evidently, some people felt some pain because the Department of Health issued an extension variance that allowed land application sites to continue operating until December 31st, 2017. So at that point, December 13th, 2017, Circle C would have had to suspend septic operations. Wanting to continue in business, Circle C on June 23rd, 2017, applied for an FDEP permit. FDEP denied this permit application for several reasons, the main being that Circle C would have to be permitted under rules for a domestic wastewater treatment facility that would output Class B or higher biosolids, as the spread of septic was banned by statute. Circle C informed DEP they could not meet the conditions of the applicable rules. The FDEP also had an issue with the elevation of the water table, and as Mary mentioned, Circle C noted it to the DEP response that the property was under 2 feet of water after Hurricane Irma. And I have a copy of this, the DEP kindly furnished me a copy of this, all these findings. With regard to residential development, would you want your children and grandchildren playing on ground that had experienced over 25 years of the spreading of pathogen-containing septic? Before any development, there should be some program of testing and remediation to ensure the property is safe for habitation. And one final point, I showed a picture there. The aerial photo in the staff package shows the numerous piles of a white substance stored on the south end of the property. Now, I've included the aerial blow-up there. I recommend the county inquire as to what this material is and for what is the purpose of it being there. It wasn't there in the 2017 aerial, but it appeared somewhere between now and 19. So again, I'd like the health aspect of this property to be considered before people live on it. Thank you.
Thank you, sir. Doesn't appear we have any further cards on this item. Ms. Rusenka?
Thank you. Again, Kim Rosenka on behalf of Beachland Managers LLC, the applicant for this project. Beachland Managers does not own this property yet, so they have not done any remediation, haven't fixed any wetlands, hasn't done anything yet because they don't own it. Until they get the zoning, they're not going to purchase it. But Mr. Giannone does intend to remediate the wetlands as will be required during any site plan or any review by FDEP or County Natural Resources. Both Mr. and Mrs. Spar talked about health concerns and health risks. There's nothing in your county code that I'm aware of or comprehensive plan amendment that has any bearing on that issue. In fact, Mr. Spar said there should be some program to ensure safety. To my knowledge, there is not. However, again, this is a business decision of Beachland Managers. They will go out there, they will have to do environmental testing, they'll have to do environmental level 1, environmental level 2. If there are biosolids that would impact health, they're going to have to remove them. There's going to be policies along the way as we go along. Just like as flooding, your county code has requirements about how high the floor elevation of the houses has to be. Hurricane Irma was a bad situation. Many people were flooded for, especially North Merritt Island, for months and months. So that was a unique situation. So whatever the requirements are going to be, they will be met at site plan. Regarding the December 17th, 2017 email that Ms. Spar referenced, again, that was the owner of the property, Mr. Colgan. It was not the applicant. As to the septic versus sewer issue, my understanding is that there is going to be a sewer connection just 3 properties to the east. And I know that because my client owns that property and they've granted an easement for that purpose. So it is preferable. Mr. Giannone has been before you before. All his projects do go on sewer. The one up in North Merritt Island, he's going to be bringing sewer. He's not here for me to ask that be put in the binding development plan. I don't know if he will or he won't. But he's going to do whatever the code requirements. And I said, I do not believe a small lot of RU 117 is allowed to have a septic tank, but I could be mistaken on that. But with that, we don't believe that there's been any evidence other than what I presented as to the size of the lot for the reasons of the rezoning, nothing to prevent this comp plan and rezoning from going forward. And also, this is the comprehensive plan amendment cycle, which others are involved with. We would ask that this not be delayed. You did hear this on September 5th. I do not believe the Spars were here at the time to raise these issues, so we could look into them further. So you've already heard this once. We're asking that you approve both the comprehensive plan amendment and the rezoning, so the comp plan amendment can go up. We will have to come back to you with the binding development plan, and at that point, if Mr. Giannone is willing to put in the the sewer stipulation, we can do it at that time. So with that, I would ask that you approve these two items.
Thank you.
Thank you.
Commissioner Pritchett.
This project, you look at this land, there's not a whole lot else you can do other than this because of the length and the width of it. And so this is the things I look for, if we do this project, is it going to negatively impact the surrounding residents? And I don't think it is. And you have a road that gets directly to the property. So again, that took care of that. Okay, and as far as there being adequate stormwater, that's the next step for you guys, and you have to get through all of them to do that. Sewer would be wonderful, but I think there is already all these properties out there on septic, so it's not unusual for the area either. And there's different criteria if you do that. And I hear the argument on what used to be on the property, but I think just from being around people that have tried to build in the past, you have to go through a lot of hoops with DEP and everybody making sure everything's appropriately safe before you'll be able to build that anyways. Or it's a nightmare for the developer when they go to sell. So I think that as far as us approving this right now to make the change and just change it from ag to RU1, I think I'm comfortable with it, Commission. So unless you guys have something to add to it, I'm going to make a motion to approve item H5 and item H6.
Okay, so just to be clear, we're doing H5, the rezoning, and H6, the comp plan. Ms. Bentley, is it okay if we do them together, or should we separate them?
It should be the comp plan first, and they should be separate.
Okay, so H6, I think, is the comp plan. So let's
Okay.
address it as to the comp plan. Is that all right?
H5 is the comp plan.
H5, I apologize. I apologize. Yeah, I think I had the advanced agenda here, and they were flipped.
You're a new chair.
Thanks. Appreciate a little flexibility here. Okay, so as to the comp plan,
I make a motion to approve item H5.
oh, hang on one second. Oh,
I'll second.
You'll
With
second
some
it?
discussion?
Perfect. Okay, any discussion?
Yeah, it's funny because we're laughing because this is Commissioner Lober's seat, and I hit the button and it says Lober on there. So he was a little confused as to why.
It threw me off.
Why he, since he didn't request to speak, why he's on the board. I just want to say, if there are any biosolids or any kind of hazardous materials out there, any health concerns, they're not going to get addressed unless this place is developed. So it makes sense to me that we would, to look at it as a positive thing. And if we're going to address the wetland issue through the planning and zoning, it just makes total sense by the time it goes through permitting. So, it's an easy support for me.
Okay, anything further? Okay, with that, I'll call the question as to the comp plan. All in favor?
Aye.
Any opposed? Okay, the comp plan passes. Now, as to the rezoning, if you wanted to do that as a separate motion?
Yes, sir, I make a motion to approve item H6 with the BDP. Yes, ma'am, thank you.
Okay.
I'll second.
We have Commissioner Risnardi seconding it. Any discussion? All right, seeing none, all in favor as to the rezoning? Aye.
Aye.
Any opposed? All right, passes unanimously. Thank you. All right, now I understand item F2 was mistakenly included in the consent, whereas it should be in public hearings. Would staff prefer it be addressed right after H1 or addressed simultaneously?
What I'll do, Mr. Chair, is I'll read both of them since they're companion applications, but they will need to have a separate vote.
Perfect, please.
So item H1 is 19PZ0066, Think Green Brevard LLC, request a conditional use permit for alcoholic beverages for on-premises consumption in conjunction with a restaurant and wedding venue in an IU zoning classification. It's located in District 1, Commissioner Pritchett. Item F2 is 19WV00017. It's a waiver request for a water requirement for the Think Green Brevard Business Complex. Staff has received 4 letters of support for the conditional use application.
Thank you, sir. Commissioner Pritchett, would you prefer to address it now or after? Okay. Mr. Buchanan?
Hello, my name is Stuart Buchanan. My working address is P.O. Box 1545, Titusville, Florida, 32781. I'm here tonight to speak on behalf of Think Green Brevard, LLC. The owners are here, as well as many members of the community that are here to show their support for our application. Commissioners, the application is a conditional use permit to allow alcoholic beverages. The property is just under 8 acres. It's 7.86 acres. I would like to point out that the applicant also owns an additional 7 acres to the west. We have an additional 7-acre parcel that's vacant to the west that helps provide buffering between us and the residential neighborhood to the west. The property is at the northwest corner of US 1 and Parish Road, so we're on an arterial roadway. They have, as the staff mentioned, we have several letters of support. All alcoholic beverage consumption is in limited areas, which are designated on your site plan. We have just recently, I can say, the North Brevard Economic Development Zone awarded us a grant of $250,000 to go towards this project. This is a shutdown citrus plant that the property is located on. The redevelopment and repurposing of citrus plants is one of the #1 priorities in the North Brevard Economic Development Plan's strategic plan. Finally, I'd like to state that we fully agree with the staff's special conditions and will be happy to apply, and we ask that you look favorably upon this application.
Thank you, sir. Commissioner Pritchett?
Yes, thank you. I think this is a good project, and I had talked to Jason Richmond earlier, and we had a couple concerns, and you sent me an email, and you're so good with those, sir. Yes? What's that? You're so good with the things you sent me on the email? Okay. So I will make a motion to approve this, but I'd like to go ahead and put in his conditions. And are we putting them in with the conditions on the CUP, sir? How do we do that?
Well, there's one condition in the staff report, and I'll read that for the record.
Yes, sir.
So the condition states provide documentation as to the site meeting county parking, section 62-306 of the code prior to the approval of the alcoholic beverage license. So if you would so indulge, you can add that to the motion.
Yes, sir. And that on-site consumption of alcoholic beverages will be limited to the tasting bar, chapel, reception hall, and patio. So I would like to make a motion to approve items, I guess it's not F2 anymore, H1 and H1B, with the two conditions we just read into the record.
Okay, and I'll take that H1B to be what was previously marked as F2, waiver of wall requirement.
That works for me.
Perfect.
I'll second.
Okay, and then we do have a few more cards that we need to get through as well. So I have Jason, is it Reichman? Okay, you'll pass on that? Okay, he's indicated he'll go ahead and pass. And Bob Schaller? Bob is here in support. Yeah, if you want to come up, by all means, I'm not going to... Okay, all right, so you'll pass then? Okay, he'll pass. And then George Taylor, good to see you, sir.
Good to see you. Just thank you for all you guys do, but I will pass.
Okay, perfect. Then Mr. Taylor's indicated he'll pass as well. So with that, unless there's further discussion, we can go ahead and call the question as to, should we do it as to H1 first, or how would you like to handle it?
Can they go together?
Ms. Bentley, H1 first? Okay, as to H1, and Commissioner Rosardi, I'll treat your second as standing with respect to H1 if we sever the two of them. Is that okay? And she's indicated that's okay. All right, as to H1, all in favor?
Aye.
Aye.
Any opposed? Okay, H1 carries unanimously. Now as to what was previously marked F2 and was referred to...
With the conditions, right, sir?
Yes, with the conditions, I apologize. What was previously marked as F2 and is now referred to as H1 sub B. This is the waiver of wall requirement. All in favor?
Aye.
Aye. Any opposed? All right, that carries unanimously. Thank you all. Then we've already addressed H2, which was continued. So we'll move on to H3, if everyone will bear with me just a moment. Okay, H3, I don't believe we have any comment cards on it, do we? No? Thank you. All right, we don't have any comment cards, and I do see this is in Commissioner Pritchett's district. Commissioner?
Mr. Calkins, how do we address this? I like the project. The residents just had a concern perhaps with maybe outdoor storage. So how do we do this without them here? I was going to request if they wouldn't mind keeping outdoor storage on the south side of the property. How do I do that without them here?
Commission, with your indulgence, let me read the item into the record, and we can have the discussion about the outdoor
Sorry,
storage.
sir. Okay.
Sure, thank you. Item H3 is 19 PZ 00113. Kim Fisher and Brian Scott Hall request a change of zoning classification from BU1 and BU2 with a BDP to all BU2 and removal of the existing BDP. Project is located in District 1, and that's Commissioner Pritchett's district. Thank you.
So now, sir, how do we approve this and limit the storage to the, oh, you are here. Wonderful, I'm so glad.
Good afternoon, Board. Kim Fisher, 1614 White Dove Drive, Winter Springs, Florida, as the applicant. I'm sorry, I didn't fill out a card. We don't have an issue with the storage being in the back. We have no issue with that.
Thank you, that'd be perfect then. I'm
Certainly.
gonna make a motion then to approve this, that we would just limit the outside storage to the south 200 feet of the property
Commissioner.
for a binding development.
Okay, we're going to put that in the binding development plan then, or we're going to ask the applicant to submit a binding development plan to that effect.
Okay, she said yes.
Okay.
Perfect.
All right, we have a motion, and the second is from Commissioner Isnardi. Any discussion? All in favor as to the motion?
Aye.
Any opposed? Passes unanimously. All right, we'll move on to H4 in a moment. If you just bear with me, we have quite a few cards, and I know I have some disclosures I've got to pull up here as well. Does anyone else have any disclosures as to H4? And there was one that was passed out that will be added to the minutes of the meeting from Commissioner Pritchett, dealing with, let's see, Kimberly Miller, with Laura Lee Thompson and Daryl Higginbotham. And then apparently I've got a light on here. So Commissioner Isnardi.
Yes, I just want to disclose, we got an applicant email from Kim Miller with letters of support on 12/4. We also got a letter in the mail from David and Joyce Craig, and it was dated November the 26th. We received it on December the 2nd, and we received an additional email with that, like, copy of that letter and a letter that they submitted to P&Z. So I think that's all I had. And if I missed any, you guys definitely submitted the emails you got as well, so thank you, that's it.
Perfect. And I've only got a couple as well. It looks like on 11/28, so November 28th, we'd received an email from David and Joyce Craig expressing some concerns about the proposal. And the subsequent day, the 29th of November, we'd received an email from Laura Kimberly Miller with a new opening statement replacing the prior one. And then she had provided some letters of support in the subsequent email. So with that, we'll go ahead and address the several cards that we have here. We have the applicant for H4. Yeah, let's go ahead and have it read in if we could, please.
Thank you, Mr. Chair. So item H4 is 19 PZ 00099. Laura Kimberly Miller requests a change of zoning classification from RR-1 to AU and the removal of an existing BDP. Subject property is located in District 1, and that's Commissioner Pritchett's district. Staff has received 20 letters of support and 2 letters of objection. Thank you.
Thank you, sir. And we'll have Ms. Miller come up if she would. I see she's from Titusville. Ms. Miller.
Hi. Hi, Ms. Pritchett. I'm under a little stress, so just bear with me while
No,
I
take
try
your
to
time.
read through this. Okay. So there's one big goal associated with my plan, and that's agriculture. But I need to remove the RR1 and switch over to AU so that I can operate my farm. And I have a long-standing goal to build my own agricultural operation. I've always loved working with plants, and I'm in the process of setting up the organic hydroponic farm that produces herbs, microgreens, and green leaf vegetables. This will be a wholesale hydroponic organic growing operation that does not involve the use of machinery, pesticides, fungicides, or heavy water. Excuse me. I will, sorry. The growing uses tiny amounts of water. Everything is planted without soil. Water is circulated from the holding tank across the plant's roots back into the same tank. The additional water is added to the tank only as the plants use it. And all the nutrients and pest control is organic only. The herbs, microgreens, and gourmet lettuces produced will be delivered to restaurants, stores, and farmers markets. I'm not planning on having people come there and shop. The entrance to my 9 acres is at the end of Eola Avenue, and as I am the new neighbor on the block, I have gotten to know 20 or so homeowners on my street and feel as though some of them are my extended family. As you can see by the letters of my support, that they are very happy and supportive with my plans to continue on with the agricultural status. I hope to have the support of the county and to be given the same property rights as every other agricultural nursery in the state of Florida and in Brevard County. The bottom line is I do need my agricultural zoning badly so I can move forward with my organic farm. I need to produce income to maintain the ownership of this beautiful natural gem and would very much like the support of the county representatives. That's all I have for now.
Thank you.
Thank you.
Commissioner Pritchett?
Yeah, I've really been struggling with this a bit. Not the fact that we might be able to grow some nice fruits and vegetables and those types of things on it. I've met with Miss Kimberly a few times and Mr. Higginbotham. They came to our office. So let me give you all some background here, because I really am going to throw this out to you guys to help me with a decision on this. Residential is really a better fit on this property. It's surrounded by houses, and they might be zoned ag, but it's really all houses. We got crickets here in the chamber here somewhere. But, crops growing here, is this a good fit? I think it's possibly a good fit. I don't think that's a bad fit. And as I discussed with them, my biggest concern would be traffic going back there. But as Ms. Kim just stated to us, Ms. Miller, that her goal is not to have people back there shopping. She's going to be bringing the items out. So I spent a little time with staff, and they said the zoning probably that's better is agricultural L, which is exactly what you're looking for. Okay. But what that does is it puts the constraints on it not becoming an actual business back there where I have to be concerned with the surrounding neighborhood with traffic. So I think if you're good with that, I would be comfortable with giving you an agricultural with a little L on it. And I think we talked about a BDP, and you were good with that. So the BDP and the agriculture L already encompasses this, and staff helped me with this. No selling of agricultural products on the property because you're taking them out. And another thing that they said would probably be a bad fit back there, and you're not doing this either, so it's just part to put in the BDP, that you're not going to have any big events without going through the process for permitting for events, which everybody has to do anyways, and that there's not going to be any camping or overnight stays for commercial purposes, and the same with resort capabilities. We're not going to do anything commercial back there except what you're planning on doing back there. And if you're comfortable with putting that in a BDP, I think in AU1, you'd enjoy it immensely, and you're going to be able to do all those things you're dreaming on doing.
Okay, thank you. I don't know the rules under AUL. I haven't seen them, so I'm assuming they're fine with what you're saying.
Mr. Tad, can you?
George, can you
Mr. Cockings?
just brief her on what the differences are?
And as he's coming up, I'll just say that was one of my, I had spoken with staff about as well, and I tend not to interfere with zoning items that are outside of my district, but AUL struck me as a real good fit as well.
Commissioner, I would suggest if we could have Ms. Miller speak with Kimberly and perhaps table this just for a moment.
Sure.
And move on to item H7, and then we could come back to it, and I would give her an opportunity to hear what the proposed uses are, what the permitted uses are in AUL, and then she can make a decision and come back.
That's fine, and I also have several other speaker cards on this item as well, so we'll revisit those when we come back. I don't want to throw anything off and not give her the opportunity to hear whatever testimony may be given.
yes, absolutely. Thank you.
Okay, so we'll call this back up in just a couple minutes.
Thank you.
Do we have to officially table it if we're moving on?
No, I don't believe we do. We
Okay.
just,
Yeah, we'll just come back to it in a few minutes. And then the next item up, because we've addressed 5 and 6 already, is H7. And I do have some disclosures as to H7, but I see Commissioner Tabaya had pressed his button there. Commissioner?
Thank you, Mr. Chair. On December 4th, I received an email from Shell Woods, copying me on an email from Commissioner Pritchett, where she thanked the commissioner for her thoughtfulness and expressed concerns with the number of lots in the water. Also, on December 4th, I received an email from Bruce Moya, criticizing email from Mary Spar in the record. And December 5th, today, I got an email from David Botto stating the belief that there could be additional hard to the aquatic preserve, that putting fill in the coastal high hazard zone has the potential to harm the lagoon. Thank you, Mr. Chair.
Thank you. Any other disclosures as to this item?
I put them in the book already.
Already in the book? Okay, and I've got a few.
Oh,
did
I
you
was
have
going to
some?
say, I have the same correspondence probably that Commissioner Tabaya, at least some of it from David Botto with MRC and Mary Spar, and they're both opposed to it. I don't know if I got a new email today from Mr. Botto, but if it's there.
And I have several from Mr. Botto. I have one from 10-3, one from 10-29, another from 12-5, all expressing concern about this or alternative approaches. And then I also have an email from 12-4 received from Ms. Farr, obviously expressing some concern about it. Last call on disclosures for the item. Anything? All right. So we'll get started. There are quite a few cards on this, but let's start with the applicant if we could. Is Mr. Moya present?
Mr. Chair, if I can read the item for the
Yes,
record.
I apologize.
Item
Thank you.
H7 is 19 PZ 00093 Lazy River Investments LLC request.
Could you speak up a little bit? The clerk's having a tough time.
I'm sorry.
Thank you.
19 PZ 00093 Lazy River Investments LLC requests a BDP limited to a maximum of 8 lots in an RU 1-13 zoning classification. The project is located in District 3, which is Commissioner Tabaya. Staff has received 12 letters of objection. Thank you.
All right, Mr. Moya.
Good evening. Thank you, Mr. Chair.
Yes, sir.
And County Commission. My name is Bruce Moya, President of MBB Engineering, representing Lazy River Investments. I know that we're familiar with this project as we've discussed it before. There was a lot of issues that came out of the last meeting, so what we've done is we've submitted a new BDP, bringing back a lot of the things that we were proposing when we were asking for the full 20 lots. Case in point, some things that we've conceded on is that condition 1 is that we will have, or condition 2, I'm sorry, is that we'll have no more than 8 lots total, maximum on the property. 3, the minimum floor area will be 2,000 square feet per home. We have changed number 4 because there was some issues on concerns about lot size, so now we will be having no lot less than 1 acre. That'll be a minimum. And to add to that, we will also would like to add to that that no lot that is within the coastal high hazard area will be less than 2.5 acres. So we'll concede to that as well. Number 5 says that we will not only comply with the current flood management criteria, but we will comply with the future flood map criteria. So we'll be making sure that we compensate for sea level rise and climate change with the new data that's coming next year. Number 6 is that we will make every effort to preserve every specimen oak on the property. I would like to further add to that we will definitely preserve every specimen oak within the limits of the current coastal high hazard area, which is most of them. I think it's all but 2. Number 7, that we will comply with the upgraded septic tanks requirements should we build within that setback. Not that we were proposing to, but we would if we did. Number 8, that we will not impact the wetland shoreline fringe. We'd like to modify that to say except for that which would be allowed for a dock. So if we could change that as well. We are still committed to only 1 access connection to Fleming Grant Road. We would be providing a 15-foot perimeter buffer on the north, east, and west. And And that pretty much is all of them. So I'm going to keep that brief. I know there's a lot of people that want to talk. I'm here to answer any questions you have now, but I want to save most of it for rebuttal, please.
Perfect. And we'll save you 1244 for rebuttal.
Thank you.
Commissioners, any questions for the applicant? Okay, we'll go right on into public comment on that. First up, we have Shelley Woods from MICO. All right, welcome, Ms. Woods.
Hi, it's good to see you all again. My name is Shelley Woods. I live at 9912 Riverview Drive in MICO, and I am president of MICO Homeowners Association. So I'm here to speak, as you know, for all the people in MICO that are not here tonight. I want to tell you that MICO Homeowners Association really likes the fact that we're developing 8 homes on this 20 acres. We are not arguing against the development. We think this development could be an exemplary development, something that we could point to and say, every developer that develops on the coastal areas needs to do exactly what this developer has been held to. And that's the problem here. That's exactly why we're here, because the binding development plan, although it says a lot of things, is still inadequate. It doesn't tell us really anything. Most of the stuff is required, and that's fine. I like the fact that they're doing the required things, but we don't know what's really happening. So Mr. Moya and I had a conversation on November 27th. It was about 45-minute talk on the phone, and he disclosed that they are planning on doing 4 homes in the coastal high hazard zone. And you may recall that our position has been, please stay out of the coastal high hazard zone. As also, you know that Objective 7 of your own coastal management system or element says to please stay out of that zone and limit the density and move it outside of the coastal high hazard area. So the coastal high hazard area is approximately 4 to 5 acres. If you put 4 homes on the river in that spot, and they're going to be 2.5 acres each, we've got also those specimen trees in there that they have to hopefully take care of. It's also an AE flood zone, which requires fill on the pad of the home. This is a big problem. The fill is going to destroy the trees. It has to. The trees are down here, and the fill is going to be up here. I'm having a big problem with this. I talked to an architect friend of mine, and he said that, well, each home to be on 2.5 acres is going to have to be like flag lots, 100 foot, 150 feet wide flag lots all the way back to create the 2.5 acres. We're having a real problem with this because it sounds to us like the coastal high hazard area is going to be filled in with homes and things. So I just feel like in the binding development plan, we need to have more clarification on that. I'm really concerned about it. We all are, because of the fill, because of the trees, because mostly, as you know, our focus is the St. Sebastian River health and the health of the Indian River Lagoon. We have a lot of development real close to the St. Sebastian River. We've got all kinds of contaminants going into it. Those contaminants are moving out to the Indian River Lagoon, and I don't have to tell you, we've all spent lots and lots of money trying to improve the health of the lagoon, and we have to a point. We have this advanced septic nowadays. We need to be using it, especially on our coastal properties. It's very important to preserve our natural resources. That's what's bringing us our tourists. If we have dead rivers, we don't have our tourists eventually. So that's our stance, and we hope that we can work out some kind of an agreement. We could handle the 1 home on that coastal high hazard area that was proposed on May 30th. And as I said, maybe I didn't say it, but I mean this to the bottom of my heart. We really need your help to do the right thing here. And I thank you so much for hearing me again.
Thank you, ma'am. All right, next up we have David Montgomery from Palm Bay. Welcome, sir.
Hi, I'm David Montgomery from Palm Bay. I've been following this the entire year, and I was surprised at the new binding development plan that was submitted. It didn't really seem significantly different from the previous one. I'd like to object to the approval of the binding development plan until more detail can be provided on a conceptual site layout that addresses the sensitivity and subject to hazard that this property has so close to the Indian River and being on the river. There's issues with sensitivity to the environment. The plan does not have any conceptual layouts that would address how the septic fields would be laid out. There's no talk of any retention ponds or stormwater management. Mr. Moy has said several times we'll use advanced stormwater management techniques, but there's been no information provided as to what those are to mitigate stormwater runoff and pollutants into the St. Sebastian River. Protection of trees isn't really addressed. I agree with previous person that mentioned that as you add all this fill, in fact, I really can't imagine someone building in the coastal high hazard areas to begin with, and that's one of my main objections. Consistent with the Brevard County Comprehensive Plan, we shouldn't be building in these coastal high hazard areas. So I would think that that would be one issue that would be addressed in a binding development plan as to how the coastal high hazard area would be developed. I also worry about risk to the homeowners that buy in this property. As low as it is, and with sea level rise and severe storm weather events causing a great deal of more water intrusion, having at least some sort of conceptual plan could assure that the future homeowners won't be held to a high hazard risk due to lack of attention to stormwater and severe weather considerations during the construction of this site. I believe that's all I have. Thank you.
Thank you, sir. All right, next up we have Mary Sfar from Cocoa.
Good evening again, Mary Spar, Cocoa. I am speaking for Sierra Club this time. The subject property appears to be the most vulnerable, or at least one of the most vulnerable, to storm surge and associated flooding in the area between Fleming Grant Road and the river. The coastal high hazard area, which is the area of storm surge from a Category 1 hurricane, is about 5 acres in size. And this area basically overlaps FEMA flood zone AE. In other words, this property has more serious constraints than almost all the properties in that area. To complicate matters, any clear cutting or fill that is added will allow more stormwater runoff carrying pollutants to reach the St. Sebastian River and the Indian River Lagoon. In order to raise house pads in the coastal high hazard area to 6.3 feet NAVD, a huge amount of fill would have to be brought in. Putting several feet of fill on the roots of trees would kill them, losing their service of absorbing stormwater and runoff. So the fact is, there is no good way to develop as usual, clear cut and fill in the coastal high hazard area and protect the Indian River Lagoon at the same time. Sierra Club is asking for 3 improvements to the revised BDP to protect the water quality of the Indian River Lagoon. No residences in the coastal high hazard area, advanced septic, and rewording of the language about the specimen oaks. First of all, no residences in the coastal high hazard area. This is not some outrageous demand. In fact, Palm Bay considers it to be so reasonable, they put the requirement in the coastal management element of their comprehensive plan. Palm Bay's comp plan policy CZM-1.6C states, the city shall not permit any new septic tanks to locate within the high hazard areas of the coastal zone, nor permit habitable structures within any high hazard zone. Right now, the applicant is placing no restrictions on the number of homes in the coastal high hazard area. Yet in the May 30th BDP for 16 homes, he limited the number of residences to 1 in the coastal high hazard area. With 8 homes, he has more flexibility and should be able to site all the homes out of the coastal high hazard area. Our second request is advanced septic throughout the property. In comment letters, DEP and St. Johns River Water Management District recommended this. The applicant agreed to put this in his May 30th BDP. The third improvement we would like to see is to change the wording about the specimen trees in the BDP back to at least to the wording of the May 30th BDP. The current wording, which I understand Mr. Moya is suggesting he would like to change, and I would like him to, hopefully you can ask him exactly what he would put there. But the current wording suggests that the applicant is looking for excuses to cut down the specimen oaks. Surely with 20 acres to work with, he does not have to put any, quote, house pad, OSTDS system, driveway, roadway, stormwater management system right where a specimen oak tree is located. We are spending millions of tax dollars on public safety related to storms. And we're also investing nearly $500 million on lagoon cleanup over a period of 10 years. Sierra Club urges you to make a responsible decision that is not counterproductive to the county's huge investments. Please ask the applicant to revise the BDP to protect the health of our precious Indian River Lagoon.
Thank you, ma'am. Next up, we have David Botto from Indian Harbor Beach. Mr. Botto.
Good evening. I'm David Botto, I live in Indian Harbor Beach, and I serve on the board of the Marine Resources Council. We congratulate you, and we definitely appreciate your careful management of this issue. This is a very sensitive piece of property. It's very important as to its impact on the lagoon. We were quite disappointed in the new binding development plan. There's really no indication of concern or coordination of how to do this job without impacting the lagoon. And that's really what our purpose is. There should be no additional harm to an already impaired aquatic preserve. Our main objection at this point is, as you've already heard, is developing in the coastal high hazard area. Even with a 50-foot buffer, there's no way that you're going to prevent harm to the lagoon if you develop or allow development in that high hazard area. There's no indication in the binding development plan or attempts to do some of the very simple and very proven items of low impact development, which we really expected in this second submittal. In light of that, we ask that you disapprove this again. And we know that's the problem for you, but we believe that this is too sensitive, too important to the lagoon to let it go as it is now. Thank you.
Thank you, sir. And our last card is Jacob Zender. Mr. Zender? And you're from Melbourne, sir?
Yep. Jacob Zender, 1750 Mosswood Drive, Melbourne, Florida, 32935. Thank you, commissioners, for giving us an opportunity again to raise our concerns with this project. So I don't want to harp on a bunch of the things that have already been brought up. This project seems like it has little bits of good and bad that keep kind of coming in and out of the proposal over time. Protection of the wetland fringe seems like a great idea. Protection of the specimen oaks also seems great. But as you all know, the devil is in the details, and there's quite a few caveats that have been stated in the draft plan that's been submitted, allowing for removal of the specimen oaks if it's convenient for the development of the property, if it's in the way of the pad, if it's going to get covered in fill. That doesn't exactly sound like going out of your way to protect the specimen oaks, which are all, the majority, as Mr. Moya stated, are in the coastal high hazard area where you're adding multiple feet of fill. So I think we are slowly moving in the right direction. So I want to stay optimistic that we can have a plan that works for Mr. Moya and his client. But again, the three things that we really need to see is get the houses and the fill out of the coastal high hazard area, advanced septic across the board for all the units, and protection of the specimen oaks primarily in the coastal high hazard area. Thank you.
Thank you. That's all we have in way of public comment. The applicant has just shy of 12 3/4 minutes left for rebuttal. Mr. Moya?
Thank you. There was some things I did agree with what was said, and I think mostly from Ms. Woods, that when she said that the pollution from what's going on there is running right into the river. It is, and that's what we're trying to prevent with this development. This would be the only development that would have a stormwater system that complies with the current regulations, which is required that you cannot exceed the levels of nitrogen and phosphorus leaving the site once it's developed compared to what it is now. Currently, everything south of Fleming Grant Road, all the way up to US 1 in Main Street, all that has no retention. It flows directly into the river and is polluting the river right now. There's over dozens of homes still that are built, still are within the coastal high hazard flood zone, existing today, dozens of them, between here, this property, and US 1. What we would do is we would build, if we did encroach in the coastal high hazard area, we would be subject to all the current rules and regulations that would dictate the elevation, the type of construction, and everything that would address the concerns associated with building in the coastal high hazard. There's properties on the river that are completely within the coastal high hazard area that could not be developed with a single family home if there weren't those rules in place. So those rules are in place so that you can do the development, so that being in the coastal high hazard area and removing it from there based on your development will cause no significant detriment to the lot itself. And if everything's directed away from the river, no effect to the river. So, and I thought it was clear about the trees that we would preserve every tree in the coastal high hazard area as it sits today. Every one. We would protect it. We would put that in the BDP right now. There's only 2 oaks that are not in the coastal high hazard area. So I think there's 11 or 12 that would be protected. We'll have no problem putting that in the BDP. And then the way I understand it, and I could be wrong, that the comp plan says that you should not increase the density within the coastal high hazard area. The comp plan for that property is 1 unit for every 2.5 acres. So by providing that in the BDP, we would be, I think, complying with that intent of the comp plan. So we would limit those lots to be 1 per 2.5 acres. The previous BDP that we presented to you last time I was here had 1 condition on it, that we would only have 8 lots. This one has 10. And we could have put a whole lot of stuff in there that is already in your code, and we don't think that was really necessary, like the stormwater requirements. That's all per code. It's per county code, per St. John's requirements, so we have to abide by that. So we didn't see a reason to put that in the binding development plan. So we think that this is fair and reasonable. We hope that you think it is too. We've been talking about this for a while. And are we meeting everything that they want? No. But we've come a long way. And I think based on the development of how that area is developed now, this is more than fair and reasonable. Because what's happening out there right now is just the Wild West. There's no treatment of stormwater going into that lagoon. So us being the new guys are kind of getting penalized by the sins of the past, where we're going to actually provide the treatment and preserve the Indian River Lagoon a lot better than what's going on out there. So I think that we can make this work with all the technology we have out there and all the requirements that the county has in their code, that we believe that we can make this a very good development. And so we're hoping for your support and your approval. So I'm here to answer any questions that you have.
Thank you, sir. All right, first up we have Commissioner Isnardi.
Yeah, I think you actually answered some of my questions. So I guess I'll just have you reiterate. Explain how say, people are building dozens of houses right now with less rules and less, nitrogen runoff and all that. Explain that a little bit more, because you brought up a lot of really good points, but I want you to explain what's happening on other properties that aren't developments versus, say, like if somebody buys a lot and builds in the coastal high hazard area. So maybe discuss that a little bit.
Yeah, the way that works is if you're just a single family home and you're building one lot, you're exempt from the subdivision code requirements, you're exempt from the stormwater requirements, you're exempt from St. John's Water Management District permitting. If you do a development like we're doing a subdivision, we're subject to all the requirements in your land development regulations.
And I realize that the land and the zoning isn't compatible. And
yes.
Again, that's the step that's supposed to follow. I mean, alternatively, if you were to split those up into single lots, there would be you wouldn't have to come before us, correct?
Correct.
Yeah. I mean, I don't think people realize, it looks beautiful and it feels right, and nobody wants development, but when you actually manage the water and any wetlands and any issues on that property, you're actually doing better. You're actually able to more manage the runoff that would head into the lagoon. So and I know that you've made some compromises as far as what you were requesting for as to where you are now. So at this point, unless I hear, some new information, I don't really have an issue with it. Because initially, if I remember correctly, and I'm not going to quote anybody, I'm not going to say it's any organization or otherwise, I thought the big issue was they didn't want you to put anything more than 1 and 1. And that was something that you, or maybe your client agreed to, and then the issues keep getting more and more. And these aren't even requirements that we're demanding of other people building properties right now. So, either we change the rules and apply them to everybody, or we don't punish one individual because the county didn't have rules in place for so many years and caused so many problems. I don't know, again, I want you to follow the rules. I don't want to do anything that's going to hurt the water. I don't want you to do anything that's going to hurt the land, but I think those rules are in place, and if they're followed, that's the right way. You're doing it the right way, so.
Thank you.
All right, Commissioner Pritchett.
Thank you, sir. Mr. Moya, how many acres are in the high hazard area?
Approximately 4.
And you said your development's going to be one house to every 2.5 acres?
The lots. When you look at density, you don't look at the actual structure, you look at the lot itself.
Okay, so it's going to be hard to put more than a couple houses in there anyways, right?
It would be difficult and probably expensive, so some people may not even want to. When the person buys the lot, they might say, I don't want to be bringing truckloads of fill. Or they say, maybe I want to build it on the stem wall. I know I got to protect the trees, or
yeah.
Who knows? But there might end up being no houses in that once it's all said and done.
We are having a 50-foot buffer?
There is a required 50-foot buffer, yes.
I remember when we were going through this the last time, we were trying to get the density changed, and I think we got to where we're comfortable with 1 to 2.5 acres. So that part, and I'm glad you're working with the Oaks. That's good. And I remember last meeting, I gave you a hard time about the septic tank, and Commissioner Tabaya brought up, he told me that wasn't fair, and I went back and thought about it, and I think he was right, that we have to do what's fair for the lagoon. So I'm still listening, but I've gotten a little bit more comfortable with the project. But let me ask you this, on the high hazard coastal area, that's mainly for flooding, and I looked at this little piece of property, and it's like tucked into a little waterway, and there's land all around it. So I don't know. I guess if you're going to build on it, you're going to have to build, first of all, you have to hold onto your own storm water. and you're going to have to build a home that's not going to flood. So I think that, you know, I'm learning all this myself. I'm sorry, I'm an accountant. I'm trying to learn it all with other things we have going on. I'm not really good at this, but the more I learn about it, and Commissioner Isnardi's got my attention a few times when she talks about when we bring in development that your requirements fix a lot of our problems. So I'm still listening, but I'm probably getting a little more favorable to this now than I was in the past. So I just want to throw that out, but I was interested because I didn't think you could really fit that many on that front since it's only 4 or 5 acres. So thank you, sir.
All right, our most festive commissioner, Commissioner Tobias.
Thanks, Mr. Chair. And I have some concerns with building on the coastal high hazard, but I didn't know if they were grounded in anything other than just basic thought. So I do have a couple questions with your indulgence for Darcy McGee and Natural Resources. Thank you. Darcy, I'm sorry I have to do this, but can you give us a summary of your education, please?
Yes, I have a bachelor's degree in applied technology and a master's degree in environmental engineering, both from FIT.
Thank you. How long have you been working in these fields related to the impact of the environment and specifically water bodies?
From 1993 to 2004, I worked in engineering consulting firms with my primary job functions being environmental assessments, remediation, and permitting. Since 2004, I've worked for the county in natural resources. I started as an urban forester. I'm now the assistant director of our environmental protection programs, which is environmental remediation and compliance and environmental resources management. We regulate, environmental resources management regulates floodplains and wetlands and surface water bodies, the Atlantic coast, obviously the Indian River Lagoon.
Thanks. So is it fair to say that you're an expert in determining the impacts of developments with regards to water quality flooding, specifically on the Indian River Lagoon?
I feel that I am an expert in the areas that we regulate. I do work with a lot of other professionals that I can collaborate with when I need to fill in the gaps of my knowledge. Our regulations are all based around mitigating potential impacts of development on our natural resources.
Okay, so getting to the meat of this, and thank you. Every time I ask these type of questions, I'm really astounded at the quality and the expertise that we have on staff. So thank you for lending that to us. While I understand that we have not had the opportunity to study the specific impacts of having septic tanks in the coastal high hazard zones, you stated during the last meeting, we asked whether the variable of coastal high hazard zone represents additional risk to the lagoon. That, you said, quote, there could be a concern, yes. Was that answer based on your education experience or a personal subjective opinion?
That was based on my education experience. I would say that we do need additional data to quantify the average range and impacts of existing septic tanks in the coastal high hazard area.
So based on your knowledge and expertise, does the directive in our comp plan to, quote, limit densities within the coastal high hazard zones and the direct development outside the area require the county to consider whether the installation of septic tanks in this area is necessary?
I believe so.
And finally, at a minimum, is there reasonable alternatives to the design? Aren't we further obligated to restrict the development in order to limit the impact on the development consistent with the intent of the comp plan?
I believe so.
Thank you. And one finally to the county attorney's office, please.
Please.
Is it a objective opinion of an expert witness based on the experience and education competent substantial evidence?
Yes.
Thank you, Mr. Chair.
All right, I don't see any other comments here. This is one of those, I really don't want to step on anyone's toes. This is certainly an issue that disproportionately impacts that area, not to say it doesn't have any meaning in the other areas that are on the lagoon. But my inclination is to support whatever Commissioner Tobias would like to do with respect to this, since this is an issue that falls within his district. So I don't know if you'd like to make a motion, or if someone else would care to make a motion to get your input on it. Commissioner Isnardi?
I have a question regarding the upgraded septic tanks. Would you Is it a possibility, like within the right location and if, even if they're in the coastal high hazard area, that they would have little to no impact on the lagoon? If they're newer and they're the updated type septic tanks?
Well, the septic overlay is meant to reduce nitrogen by 65%, and the distances chosen by the board for the cutoff for that overlay was never meant to completely eliminate nitrogen impacts to the lagoon. You're still getting nitrogen impacts as you go further away. It's just that kind of breaking point of, looking at the costs to remove the nitrogen from the system versus, the property rights and, people's pockets. There was that tipping point that was chosen by the board. So yeah, you're still getting nitrogen impacts from even the advanced treatment. It's just not, you're reducing it by 65%.
Right, and would you be able to gauge or to say with certainty that, not developing and not managing any runoff that currently exists, if that would be greater or less than, say, a high-tech, a minimal nitrogen releasing type upgraded septic system?
I spoke with Virginia about that and trying to figure out if there was some way to quantify this before we had the meeting, and it would be, we'd have to do that delta in there, and it would take some time and some money to really quantify it, which, we have not been directed to do. Right now, there's no runoff coming off that property that has nitrogen in it. I mean, the trees are there treating stormwater that does enter the property, so there's no additional loading from septic on the property at this time.
But there are a lot of other properties, single-family residences, that don't have BDPs, that don't have any sort of plan or limitations to acreage right now that are being built that don't have to come before us or adopt those new rules, correct?
Yes, that's correct. Unless they're building in the septic overlay, then of course they would have to do the advanced treatment.
Right. See, so even if they were single-family residents having the septic, they would just have to have the advanced septic system, correct?
Yes, and of course, they'd have to meet the floodplain if they're, yeah, okay.
Right. Because again, I think, and Commissioner Pritchett brought it up, that coastal high hazard area has a lot more to do with flooding than it does environmental impacts, as far as it impacts the property more than it does because I understand both sides of it, and I think you have to, again, balance that property rights versus responsibility, but you can't expect one development who appears to be trying to do everything responsibly, appears to be trying to work with neighboring people in the neighborhood. You can't deny them and expect them to fix all the problems of past. And the problems still that are existing today that we're allowing right now. So I don't know how we put that all on a developer and ask them to go above and beyond when we don't have those same expectations of people building houses right now in the coastal high hazard area. So again, I don't know how you change the rules for one. I mean, his client could easily break up those properties, it's sort of the county's responsibility to make sure the land use is compatible with the zoning.
Mr. Moya, just very briefly.
Which should have been done in the past, and that was another question I had that I forgot to ask you. Why that wasn't done in the past.
Well, I'm willing to offer, if this allays some of Commissioner Tobias' concerns, that we would add another condition to the BDP that no septic systems be placed within the coastal high hazard area.
Thank you, sir. And
one other correction, I wanted to correct one thing that Darcy said. Their existing vacant properties do have nitrogen and phosphorus that do come off the property and naturally occurring based on the criteria that was established by the University of Florida. There's no such thing as zero. There's some. So what we have to do is we have to match whatever that is or less. So it's never zero. Even vacant property contributes nitrogen and phosphorus. So I just wanted to correct that.
And just for everyone's edification, we're going to go to Commissioner Pritchett, then Tobias, then Smith after this. So Commissioner Pritchett?
Yeah, Commissioner Tobias, thank you for going through that with Ms. Darcy. And I agree with Commissioner Lober. I mean, you guys, I do so much research on things in my district trying to figure out what to do. So I know Commissioner Tobias put in that time. So I think the key is to figure out what's going to make Commissioner Tobias think that it's appropriate in his district to do that. So, I'm listening to what he's going to negotiate here. But you know what? Even on the sewer and the septic, the sewer lines leak too. So, it's good having the high-end ones, but even if it's sewer, we got problems, guys. So there's no perfect thing because we just have waste problems altogether. But I'll be interested in hearing if Commissioner Tobias is agreeable to that. But I really wish that we could have worked this out with him before we got here to see what he thought was appropriate for the property. But again, I'm not as much against it as I had been, and I've been really struggling with this. So Commissioner Tobias, you're on, sir.
All right, suspense.
Thank you, Mr. Chair. I had three concerns, and first of all, with the trees, and it looks like you did a good job ameliorating those to my standards for the first one. So I appreciate that. The second one was the septic tanks located in the coastal high hazard. We discussed, I was concerned, though further than 65 feet or 60 meters or whatever the heck it was, that we would go with anaerobic. I know you hadn't at our meeting agreed to that, but you just said 2 minutes ago that you wouldn't put any septic tanks in the coastal high hazard zone, which means you've gone above where I was. So 2 for 2. Here's the third one, and that is the number of homes. And I'm not an engineer. I'm not all that bright when it comes to layout or many things, but I'm trying to figure out if you're going to have, I'm just laying the piece of property out in my head, how many homes that you can put in that coastal high hazard zone. And you said there's a possibility of no one wanting homes in that high hazard zone. I'm just trying to get a comfortable number here. Obviously 0 would be the best, but your client may think otherwise. When it comes to doing flag lots and lots that are extremely narrow, I think you could have put at least 6 lots. I'm just thinking about that in my head, and based on what we've drawn in the past in that coastal high hazard zone. And even if the septic tanks were not in there, I certainly would be a little bit hesitant the amount of fill, all that other things that would go on. Is there a number, that you can give me as to the number of residences? You said
no more than 4. No more than 4.
Tell you what, I'm a lot more comfortable. I'm a lot more comfortable with 2.
I appreciate
that. I heard the testimony here from what sounded like a pretty darn good expert to me that said there could be an impact on the lagoon's health by building in the coastal high hazard zone. Certainly there's no evidence to state that it's not an impact. So I want to keep that as diminutive as possible. And in all honesty, 2 is where I'm at. You said it could be 0. I hope it's 0.
Yeah.
But
it's up to
again, you've got 4 other commissioners up here. And I don't see this just as my area, because the health of the lagoon is something that impacts all 4 of us. So, and the 580,000 people in Brevard County. So I certainly appreciate the deference that, my fellow commissioners, lay on me. But I appreciate also the 2 of the 3 things that were concerns to me. You've met them, and even the third, you've come down quite a bit. But it just can't get my support until it goes down to 2. But I greatly appreciate the time, effort you've put into this.
Okay, I do have a question then. I guess the way I would see if developing the coastal high hazard area is an impact, I could see two ways would be an impact. One, you're reducing the flood area, the flood volume, and then the other one would be stormwater runoff. So if we address the stormwater runoff, because we can't just directly discharge to the river, we have to treat it to the standards of the county and the St. John's Water Management District, so that we're less than or equal to what's happening now. Then we're limited to the fill being an impact. The Indian River Lagoon is an estuarine floodplain. The county does not have any regulation for compensating for fill in an estuarine floodplain. And I think Darcy will verify this. So if filling it's not an impact and the drainage pollution's not an impact, I guess I don't know what other impact might be of concern. So that's a question, if somebody knows what that might be.
Mr. Moy, I'll let Commissioner Tobias address that, then we'll move on to Commissioner Smith and then Isnardi.
Thank you, and I appreciate your expertise. However, That's why I spent quite a bit of time qualifying Darcy on this one. It's outside of my scope. My question was very simple, is putting homes, and sorry I had to go through all that, but it's important to qualify her as an expert, as she does have quite a bit of qualifications and a pedigree. But clearly there is that possibility. I don't have the ability to answer that, but I'm sure staff has the ability.
Would an additional building setback from the river be something you would be interested in entertaining? For more than 50, we would make it more.
I don't know how much further it goes off the coastal high hazard. How much further than that 50-foot buffer is it?
In parts, it's average, I'd say about 400 feet, which is way more than anything existing on the river right now. It averages from as little as 10 feet to the river for a home that's out there now to as much as about 200. With most of the homes, well, I'm saying most, but a lot of the homes are at about 150-foot setback from the river's edge. I have authority to make that a condition that we would not have any homes closer than 150 feet from the river's edge, which would make it very compatible with a majority of the homes out there right now, which would be minimum impact to the coastal high hazard area should somebody decide to build in it. It gives us
Mr. Moya, I apologize for cutting you off, but I know Commissioner Smith has been waiting pretty patiently here, and I'll let Commissioner Tobias mull over that in the meanwhile, and he can pick up on that where you left off. Commissioner Smith?
Thank you, Mr. Chair.
Sir.
My question is directed to Eden. Correct me if I'm wrong, but if a developer, in this case, if this developer decided to sell the lots and not build on them to individuals, and say he sold 8 individual lots. From what I'm hearing today, those 8 individuals could pretty much do whatever they wanted with those properties. No. Is that correct?
Yes,
they wouldn't be restricted by all the restrictions that we're trying to impose on.
It's a little bit of a yes and no answer. Individual lots do have fewer regulations than subdivision developments. But because you have a restriction of 3 lots before you have to follow the subdivision regulations, the creation of 8 lots doesn't work the way you just described. You would have to go through the subdivision planning process to have 8 lots.
Well, I'm thinking that if the developer just put these up for sale and you had 8 individuals come along over the period of 2 years to buy 8 lots, they're still subject to the 3.
If you were not captured by the regulations as you should be, it could happen.
Okay.
You should be captured by the regulations.
Okay. So that's point 1. So at least we have some control at this point. That's point 1. Point 2 is I have the LiDAR map here, and I don't know if you guys have this or have seen it, but
no, sir.
You're looking at 1 foot here, 2 feet here, 3 feet here, all the way back here is 3 feet.
And Commissioner, can you just turn it around momentarily, at least so the folks that are watching on TV have a chance to take a peek?
So,
thanks.
As I said, it's 1 foot in here, 3 feet, all the way back here it's 3 feet, and all the way up here it's 18 feet. So you can see there's whatever water is coming in here by way of rain wants to come this way. And whatever is up in here, if it's on the surface, it's going to wash down into the river. So from my perspective, and I don't have any real dog in the hunt outside of my love for the Indian River Lagoon, and I really want to go with the direction that Commissioner Tobias wants to go because this is in his district. But personally, I would like to see no houses built in this area because it is so low. But if you're saying that you would restrict an advanced treatment unit, so if somebody built here, they would have to put the advanced treatment unit back here somewhere. So you would have to have a pretty deep hole to cause it to run downhill. Is that correct?
Oh, yeah, or we could pump it, whatever we'd have to do, but it would be out of that.
So, okay, well, that's my 2 cents. I'll leave it up to you guys to.
Commissioner Isnardi?
I almost forget my question now.
Sorry.
Let me just look at my notes here.
Sure, take a moment.
And I think Commissioner Smith addressed it when I talked about the 1 acre lots, because I was going to discuss that again. But I did want to ask you, why wasn't the zoning and the future land use fixed a long time ago? Do you know the history of that?
I don't know the history. I was told that there was a history that the county staff was aware of this a while ago under a previous director, that they were supposed to actually go and, because getting incompatible zoning with the land use is unheard of in any of the cities within the county. They all have.
And I
their
think
zoning
that's what I was
incompatible.
like, I could not understand.
So to have it in this condition, and this isn't the only property. There's plenty of properties in the county that have incompatible zoning and land use. But that effort was just abandoned. And so it's up to the lot owners to come to you and ask to make it compatible. That's my understanding. Maybe there's more to it, but
Do
that's
we know?
what I've been told.
As a county, do we know that before everybody's time?
I'm not aware of us proactively going out and administratively zoning properties, at least since I've been here. I won't say that it hasn't happened. There are provisions in the comp plan for that, but I don't believe that that administrative authority has been granted to me as the zoning official. And I believe that lies with the board. So if the board were to tell us to administratively rezone a property, then there are provisions in the comp plan to allow that to happen.
And that's probably a discussion for a later date, but maybe that's something that can come back to us to at least look at the possibility. Or if it's something of concern, maybe it comes back to us, but I think that this is part of our problem,
Yeah, and that's kind of where my number 4 comes from, because if we had compatible zoning on this property, we could build 4 lots and we wouldn't be here. With just throw the subdivision rules out the window, we could build 4 lots if we had the compatible zoning, and that's where my number 4 came from. And I hope that, I think we've jumped up every hurdle except for maybe one. I hope that we've come far enough.
And I think the 150 feet is acceptable. And you agreed not to put any septic tanks in the
Yes,
in the
ma'am.
coastal high hazard. So there's going to be no septic tanks in the coastal high hazard area, which is pretty awesome. So.
Commissioner Tobias, I don't see a light, but I am going to see if you do have any input nonetheless.
Well, I'm sitting back listening, and the longer this goes, the more I appreciate it. Thank you, Commissioner Smith, for bringing this out. And when you held this up and you said all of the septic tanks behind it are going to be the advanced treatment septic tanks, and you agreed. So to be clear, all the septic tanks on this entire property are going to be the advanced?
Outside. No, they'll be outside the coastal high hazard.
Okay, so
There'll
that's
be no
different.
septic.
That's different than what you just. Did I misunderstand you?
No, that's what I was going for, because you see that little jagged line there?
Sorry,
above-
what were you going for? That they were all.
That there would be no advanced treatment units within the high hazard, so it would have to be above that
correct
squiggly line.
Yeah, he'd already conceded to that. Okay, so yeah, that was not an add-on. That was a concession.
No, I was confirming that, but that's.
Okay, that was a concession that he made. Darn it, I understood differently. Yes. I don't know where this is going to go. In all honesty, that's what makes Sunshine a heck of a lot of fun. I'll tell you where I am. I appreciate the additional setback, and I will. We'll see what the river card comes up, but I'd be willing to play 3 homes in the coastal high hazard zone. It may not work. But 3 homes in the coastal high hazard with no septic tanks, as well as the provisions if you made in the trees. I would be amenable to that. But outside of that,
Commissioner, when you say no septic tanks, you mean none in that area and they have to be relocated up?
no septic tanks in the coastal. He's already.
Perfect. I just want to be clear.
Yeah.
Thank you.
Coastal high hazard zone.
It looks like it's 4. And there's also another partner, and he told me 4, so I can't go any lower than 4.
Understood. I appreciate that.
I'm trying to do backflips here, but that's just the one thing that the river is this whole property. I mean, that's why everybody's there. And you just got to take advantage. The property doesn't have any value if you can't, take advantage of the riverfront in some form or fashion. And
Understood.
they're only asking for 4. And I think, like I said before, if we had the compatible zoning, we would have that.
Commissioner Smith?
Thank you, Mr. Chair. So you're saying that you want to be able, if people are interested, and that's what they want, that you want to put 4 houses in this area here, a maximum of 4.
Correct, but if you do that, it won't look like that anymore. You'll file a LOMR with the state, and the coastal hazard area will be reduced.
So you'll bring
So you
in a
won't-
lot of fill?
Or you build it on the stem wall. I mean, there's all ways to do it, but it would no longer be in the coastal high hazard area once you do your development.
So
Just like getting out of a
how high
floodplain.
do you think, and this is a tough one, I know, how high do you think your stem walls would be? 3 feet?
I don't know.
Well, I'm just
Could
wondering,
be,
because if
yeah.
you're looking at 1 to 3 feet of land that's above the sea level here,
Right. Well, the finished floor would be, and based on this, would be a minimum of, I think it has to be 12 inches above the 5.3, which would be the new flood elevation when they come out with the new maps next year.
okay, so,
As to where almost none of those houses are going to comply with the new rule once that comes out. That floodplain is going to go a lot farther towards the road, and a lot more homes are going to be in the floodplain that are existing now. So
Darcy?
none of them.
I just wanted to clarify one thing. The fill can take you out of the floodplain, but the coastal high hazard area remains the coastal high hazard area. You can't remove yourself from that designation. Just wanted to clarify that.
Thank you.
that's good to know.
No, I thought that was not true.
I conferred with Frank Scarvellis, our floodplain manager, and that's what he related to me,
Okay.
so.
Good to know.
Just as an FYI, I'm permitting a little bit more back and forth than I ordinarily would in the hopes that we can resolve this in some fashion. If we can't, I apologize, but if we do, I think this is worth it. Commissioner Pritchett?
Ms. Darcy, if we bring fill dirt into the area, what impact does that have on it as far as flooding?
Well, the fill is going to, Bruce is going to have to do engineering to deal with the stormwater, so flooding should not be an issue. It's the other impacts of fill when you're putting, going to 6.3 feet, when you're at 2, you have other impacts to trees and.
Right, so my question is, if they bring in the fill and they take care of the problem with the flooding, and they're already maintaining their stormwater, then what's the downside then of developing on that if they take care of those items? What's the problem here with this piece of property?
From a safety standpoint, if they're filling to a height that's going to be above those, quote-unquote, the hazard area, but keep in mind, it's also a Category 1 storm surge. So if we look at it from 2010, you'll see it was further back towards the water, and in 2017, when they revised the model, it's now moved inward. So, I mean, theoretically, in the future, you could see that coastal high hazard area creep towards the land. And now we're getting into climate change stuff, but that's long-term.
Commissioners?
Right, but if we bring in the fill dirt and raise the level of the land, what have we done to cause harm then that makes this a problem if he fills it and builds on it? What's our problem then if we do this, if he's containing the stormwater?
Well, I think the problems come in depending on your perspective of fill in an environmentally sensitive land that is vulnerable to storm events. And as we go through the decades here in Florida, what is safe in 2020, is that safe in 2050? I don't know. I'm not saying it is or it isn't. It's just a decision that, something you may want to think about.
So are we saying this still remains a flood area? Is
No,
that what we're?
I'm sorry to interrupt.
No, it's okay. I'm trying to get an understanding of this.
It's complicated.
Okay.
So the flood zones are based on elevations.
Right.
So we know now that FEMA's increasing that base flood elevation. So here floods now, here will flood when the new maps come out. They're going to say, no, we think we need to make that higher. People should be higher because here's, John, please correct me if I'm misstating this.
I'd like to try to clarify.
Okay.
Add to what Darcy is saying. The coastal high hazard area is based on a mathematical model of what happens with a storm surge during a hurricane or other types of events. And it's based on water that is driven by wind. And so when you alter the areas that can be flooded by those floodwaters, those storm surge waters, then it prevents it from going to those locations, and the water tends to want to try to go to another location. So what winds up happening is that the surging water from the hurricane winds up seeking other areas to go. So filling in the coastal high hazard area induces changes to the behavior of the water or the storm surge that's occurring. And so the danger is not necessarily to the project that is being developed, but to other properties that have either already been developed or remain to be developed, and can alter the conditions that they would experience during a storm surge. So it's a little different than a regular flood. It's basically moving water that's moving around due to the wind that comes from a hurricane.
So this could cause harm to other areas.
That's correct.
So what if instead of bringing in fill dirt, you did that, but they were all built up on stilts and you didn't have to bring in dirt, therefore we're not changing the ability of the water to go there in hurricane times?
Build up on stem wall, I mean, it's the same. Stem factor was have dirt just in the.
Sir, if you're going to, I'm going to have to ask you to come up here and
But
speak.
what if, I don't know, I'm going to have to see if Commissioner Tobias is comfortable with this. What if they're all, we put it in the BDP that they are built up on stem walls, therefore we're not,
Stilts, you mean?
yeah, that word.
Being
We're
a
not-
builder for 37 years, I'm David Starkey. I live right next door at 3400 Seabird Lane. I've lived there for 16 years. The water has never come up higher than about maybe 10 or 15 feet up into our backyard during storms. I mean, stem walls can accomplish not having to fill around the pad. You'll have steps up to your house, and you don't have to kill the trees and the vegetation around you with the amount of fill that you put in. Very common practice to limit the amount of fill. It's an individual's determination whether they want to spend $20,000, $30,000, $40,000 on filling a pad. It happens all the time. I do it all the time. Deer Run, many of the surrounding areas in Valkyria, I've built hundreds of homes there. And, you know, do you spend $50,000 on fill, or you put it on stem wall and spend $15,000 on fill?
This
So,
might be an option for Commissioner
you know,
Tobias.
but-
Maybe it would be something he would like.
You know,
Let's hear from
that
Commissioner Tobias. I just want to kind of get things moving a little bit on this, Commissioner.
I'm still comfortable where I am, even slightly less so after Mr. Denninghoff mentioned that this impact, I didn't see the impact of the neighbors. It sounds like this may impact your house, right next
it
next
could.
door.
I mean, I'm planning on selling my house and moving next door, so when it
Right, so
gets
we're-
developed.
That
so-
doesn't help your argument, sir.
You're right.
That
it does
that
not,
actually
but
hurts your
I don't think
argument.
it's going to impact. There's numerous houses along the river right now that
Sir.
are being built on
Sir.
0.6, 0.2.
I apologize. I've got to cut you off because
All right.
Commissioner Smith has his button on here. Sir.
Call me Edie. I just have one more thought for Commissioner Tobias to consider. You have 4 houses in this high-impact zone. The Florida dream is to have, not by me, but an awful lot of people have the Florida dream of lush green lawn, lots of fertilizer, lots of nitrogen. You're basically not much above swampland here. Are these people all going to want nice big fancy green lawns and loaded with phosphorus and nitrogen fertilizers? What's that going to do to the condition of the river? Just something else for you to think about.
I think,
Not to put any pressure on you.
yeah, looking at where we are, without there being any more lights, we're kind of at a juncture where either there's going to be a motion to approve it, a motion to disapprove it, or we're not going to take any action. So how would you like to drive this boat, Commissioner Tobias?
No, I certainly, you're the chairman. I certainly don't want to drive the boat. I think my position's been made very clearly. I'm willing to do it I'm willing to vote in the affirmative should there be the setback that was offered, and no more than 3 homes in the coastal high hazard zone. If there is not that made as a concession, I will be voting against it. However, there were four other independent votes, and I sincerely respect anyone else's opinion should they vote that way. So I'm going to sit back here and let you drive the vote.
Well, Commissioner Risnardi may be driving the boat. She's next. Commissioner?
Well, I mean, we're just kind of going in circles. I think, and this is no shot at Commissioner Tobias, but I think, the 150-foot setback, the no septic tanks, as Commissioner Pritchett and a lot of us, I think, were concerned about. I think the difference between 3 and 4 houses when you're talking 2.5-acre lots is really insignificant. So if Commissioner Tobias is willing to support 3, I'll make a motion to support it with 4 with the conditions that nothing is built before 150 feet, that there be no septic tanks in the coastal high hazard area. And obviously you have to go through the process through our departments to make sure that your stormwater is managed. And I would just caution you, if Mr. Denninghoff has concerns about any stormwater runoff, there's going to be runoff from anything that you build anywhere, whether it be a single-family residence, whether you be on 10 acres or 2.5. I would just ask that you obviously try to create areas of stormwater retention, which I'm sure will be in your plan. But with 2.5-acre lots, I think that that's sort of, very nice for that area, because you have developments close by that are much smaller than that. It didn't have to come before this board or any, because their stuff was compatible with the land use. So that's my motion.
Commissioner Pritchett?
I really like what Commissioner Tobias brought. I have a feeling, though, if you brought them up on stilts, we might accomplish it. So I would second that if they would agree to those houses they build on the front to be up on stilts and have less impact to fill dirt. Stem walls.
Mr. Denninghoff, do you have anything you'd like to chime in with respect to stilts versus stem walls? I apologize for putting you on the spot.
Well, I heard the term stilts and I heard the term stem walls, and they're very different. One thing that hasn't been said is that the ancillary facilities, accessory structures associated with a home are supposed to be built out be built outside of the 100-year floodplain or above it. And so I'm not sure exactly how they would do that with a stem wall or with a stilt-type construction. It would be interesting to see how it goes. The only other thing that I would offer is that the geometry of the lots is what we don't know and don't understand right now, because it hasn't been presented to us. It's not required at this time, but that is leading to an awful lot of the questions and concerns that people have.
Thank you, sir. All right, we have a motion. Do we have a second as to Commissioner Risnardi's motion?
With changes or no changes?
It depends on whether Commissioner Risnardi is amenable to those changes.
Depends on what the applicant would want.
Okay, I'm seeing the applicant is referring, or is motioning in the negative. So it looks like they're not amenable to those changes.
And if I don't get a second, I find it odd that I wouldn't get a second, considering that Commissioner Tobias was okay with 3. So the difference you're talking is one house, when you potentially could be talking about one, if you ever went R1.
I'll put this out there. Were this your district, I would support the direction you wanted to take on it.
And if he was contesting my motion, then I would pull my motion, but he's not. Commissioner Tobias is not, sorry.
All right, we'll give it a couple moments, and if we don't have a second, we're just not going to take any action on it, and we'll move on to the other item.
Oh, I'll second it and see where we go.
All right, we've got a second. Any further discussion? Yeah, I think we're all talked out on this one. All in favor?
Aye.
Any opposed? Nay. Okay, it fails 3-2 with Commissioners Tobias, myself, and Smith in the negative. So we'll go back to H4. I know folks have been patiently waiting with respect to that. I know we left off with Ms. Miller, and we'll give her an opportunity to come back with the remaining just over 12 and a half minutes that she has. But before we do that, I do want to address the other folks who have not yet had an opportunity to speak on this item. We'll have, just to give folks the lineup here, We'll have Carrie Poulter, and then Kalina Schmidt, and then Roan Poulter, and then Daryl Higginbotham, and those are all the cards we have. So Miss Poulter, if you'd come up. Say again? Okay, they were all with you? Okay, so they've all left, I understand. So all of the cards for H4 have been addressed. We'll go back, I guess, if commissioners have any questions for the applicant, or if the applicant wants to come up, having had the opportunity to speak with staff.
Okay, there's a
I'm
couple.
sure you're just praying it doesn't go as long as the last item.
No,
It should.
and I'm tired, so I may miss a few things, but there are just a couple things in AUL that I want to maybe try to write out. I don't know that when that would happen, but it's confusing because it says for non-commercial use under agricultural pursuits. And so, but according to Mr. Ritchie, non-commercial use doesn't mean that I'm not selling commercially. It just means that I'm not selling commercially from the property. So those kind of things need to be spelled out for me so that, because to me, I'm selling commercial
Mr. Calkins?
plants. So that's the confusing part that I would like to have added in there. And I don't know.
If you would, sir.
So I think what Ms. Miller is suggesting is that in the binding development plan, that there would be an allowance for her to have wholesale sales there through the property, not retail sales off of the property.
That could be.
Because the commercial aspect of the AUL is what we're, or I should say, I'm sorry, the commercial aspects allowed in the AU zoning allows for sales on the property, like a farm stands and stuff like that. And so those would be the things that we would be looking at, from what I understood from the board, and why the suggestion was to go to AUL would be to not allow that kind of activity.
All right, Commissioner Pritchett, I see you have your light on.
If you have like a wholesaler wanting to come and look and see if he wants to buy your product, that's like one person going out, and then that's not going to be a troublesome aspect for the property, and then you take it out of there and sell it.
Right. So that's considered wholesale. That's considered
Does
wholesale.
that work in AUL? Because that's still my struggle, because AU can open up a whole thing in an area that's really residential. So is she allowed to have somebody come in and look at the product, and then the product's moved from the property out to where she's wanting to take it?
And I believe that I would say that she would be allowed to have someone come in and look at depending on the sales. What she or what I heard her say earlier is that she was going to be doing herbs and microgreens and things like that. So that activity would probably be a package and sell mobily to a restaurant or some other thing. So that activity is allowed to happen in the AUL. If you get into a tree farm, it's harder to move the tree, right, to somebody's if it's planted in the ground. And so that activity, you would have someone come look at the tree, and then they would be purchasing maybe several trees, and then those would then be relocated or dug up, transported to whatever facility they need to be transported from. So I would say that kind of activity would be allowed under the AUL as well.
Okay.
I don't anticipate people coming back there to look at like herbs anyway, but commercial needs to be defined for me. I feel like it needs to say that it's commercial.
Well, if you're allowed to do all the things you're wanting to do on there, you're going to get to grow it.
Yeah.
And take it out and sell it. I think the AUL is going to fit. You're going to be completely in compliance if that's what you're doing.
Yeah. I just, when it says non-commercial, to me it says something different. It says that I'm doing it as a hobby. That's what it says to me. So I'm sort of, what I'm saying is it's personal and hobbyist is what this reads to me, even though that's not what Mr. Ritchie and you all are saying. It reads to me differently, and down the road, is that always going to read the way you're reading it, like
Ms. Miller,
this? Yeah.
If I may, just, I think to make this a little easier on you,
Okay.
and I understand your concern, but all of this is audio and video recorded for posterity.
sure.
There is no question that we're telling you what we're telling you, and you can rely on our assurances. And if it makes you happier, as long as Ms. Bentley doesn't see any problem with it. I'm happy when there's a motion made to include with that motion, or have included with that motion, a request that staff interpret any concerns that may be brought up in the future in light of the discussions that we've had today.
Under the code, Mr. Calkins, as a zoning official, is authorized to interpret the code, and I think he has just done so.
Yeah, I mean, I feel comfortable with that. I mean, if were I you, I'm not trying to give you advice to take it or not take it. That's certainly on you.
Mhm.
But I think given the fact that we have an audio and video recording and we're all telling you the same thing.
Okay.
The other question is, if you were to suggest that you weren't amenable to that, what the alternative is, and I don't know one way or the other whether you would get anything if you weren't amenable to it. So I would have to defer to Commissioner Pritchett on that, as I'm going to follow her lead.
Okay.
But I don't foresee code enforcement coming after you for doing what we've discussed.
Okay, yeah. And should I discuss the rest of it later, or did you want to finish it now?
No, we're going to make a motion here
Okay.
soon on it.
Yeah,
All
So
right.
if you're
Okay.
agreeable to AUL with
Yeah, yeah.
the binding development things that we talked
I'm
about.
agreeable to that, yes.
Okay.
And then there were just like one or two other little things we could talk about.
Well, you have to tell me now, because we're going to make a motion.
Oh, okay.
Okay?
It says, okay, under permitted uses under AU, it says plant nurseries are allowed. Under AUL, it's not listed.
But we just specified you can do the plant nursery, correct?
Yeah, so the
Okay.
difference would be is the plant nursery under the AU would be where all of us could go and look at plants and purchase them.
We're not doing
Through-
that.
Yeah, we're not doing that.
No.
Under the AUL, it would be that you could have the nursery and grow the plants, but you would locate the plants someplace else for
Right.
sale.
Okay, and then further down, it says, I don't know what page it was on, but something about having machinery there. I don't know where it is. Storing equipment and machinery. In the definitions of plant nursery, it says, on-site storage of commercial vehicles or heavy equipment shall be prohibited in the BU1 or agricultural zoning classifications, that sort of thing. I'm looking maybe to have a tractor. I'm not looking to have forklift loaders and things like that, like they would
Yeah.
have at Home Depot.
So I think that under the definition of the AUL zoning classification, which you were concerned about, where it talked about the, pardon me, I'm trying to find it here, where it said agricultural pursuits of personal, non-commercial nature, I
Right.
think was raising your concern.
Right.
So if you had a tractor that was there for your personal use of the property as agricultural, that would be fine.
Okay.
If you were storing tractors for other folks, or you had tractors or equipment for commercial production, then that would not be allowed.
Okay, all right, thank you. I think that's it.
Okay,
So if you're amenable to that, I'd certainly entertain a motion.
wonderful. Then I'd
Okay.
like to make a motion
Yes, please.
to change the zoning on this property to AUL with the binding development limitation of no selling agricultural products on the property, that no outdoor events without you going through the special event permitting process.
That includes gator wrestling, I take it?
Gator wrestling too. No camping or overnight staying on the property commercially, and no resort or tenant dwellings on the property.
What's
All right, I'll go ahead.
what's a tenant dwelling? I know, what does that mean?
Mr. Calkins, you're on the spot again.
What- yeah.
So,
What do you, what-
so tenant dwellings is associated with like short-term rental and
Okay.
items like that.
No
so.
problem, got it.
I'll
Fine.
go ahead and second it.
That's it.
Any further discussion? Seeing none, all in favor? Aye.
Aye.
Any opposed? Passes unanimously. Congratulations.
Thank you very much.
I apologize for the wait. That last one was a bit contentious.
No worries, have a good evening, everybody.
Thank you. You too.
Thank you.
All right, we're going to move on to H8, as long as everyone's still semi-conscious up here. I know it's been a long night, and we'll try to keep powering through if we can. I do have one disclosure. We received my office received an email from David Botto on the 5th of this month expressing his concern about the project. Oh, actually, yeah, that's the only one I have. I apologize. Any other disclosures?
I have one, just trying to read it, I wrote it a little bit over it. It was one requesting a clarification of a section, subsection 4, regarding properties demonstrating discharge of runoff directly into the IRL being exempt from compensatory storage, and that was from David Botto. I just wanted it clarified, what it's meant by that in there. And I think that was it.
All right, perfect. Anything else? All right, we've got several cards here. I'll just read out the list in the order that we're going to call them so that folks can get lined up appropriately and be prepared. First off, we're going to have Jack Ratterman from Merritt Island, then Tammy, I think that's Dabu? Dabu. Oh, yes, it is. Okay. From Merritt Island, Phil Bernardo from Merritt Island, Darlene Hunt from Merritt Island, David Botto from Indian Harbor Beach, and then Sandra Sullivan from South Patrick Shores.
That's K.
Oh, I'm sorry. That's for K. So less the last one. I apologize, Ms. Sullivan. Mr. Ratterman.
Good evening. My name is Jack Ratterman. I live at 568 East Hall Road. The house that I have butts up against or faces this area of concern. I respectfully request that you approve the ordinance. But I have one concern, and that's with the determination of the elevation of the sea level. This year is the first year that I have water still remaining in the savanna behind my house up to 4 inches. And I called Jim Wham, who's head of the Road and Bridge for Merritt Island, and he also stated that the water level for Merritt Island and the river was extremely high this year, and it wasn't until this last week, maybe Mr. Smith can vouch for that the water level is finally going down a little bit. So each year, it appears that the water level keeps rising. God forbid we would use sea level rise. But would each year we would use the most current data, and then how would that data be achieved? I'm kind of asking Mr. Denninghoff that.
All right, Mr. Denninghoff.
I'm not sure I can give you a clear answer to that. I can try. The model that we expect is going to be generated by this effort will take into account a great many factors, and a lot of it's going to be associated with groundwater levels and obviously rainfall and many other factors. But the ease with which that we would be able to modify the model based on a sea level rise sort of factor, I'm not sure that we can do that in a reasonably easy or quick fashion. We might be able to. So it's something we could talk with our consultant about and see if there's not a way to be able to do something like that. But I just couldn't tell you right now that we'd be able to do that in some sort of readily achievable thing on a short-term basis where we could just sort of reevaluate it every year. This is a huge effort that takes quite a long time to generate. So I just don't know that we could do it quite that easily, but perhaps so. That's the best I can tell you.
Would that elevation have to be approved by the commissioner if it was reevaluated?
Our anticipation is that when this model is completed, that we would be bringing it back to the board for implementation acceptance by the board. If we were going to make a change to that model, I think we'd have to do that over again.
And Mr. Ratterman, if you have any other questions, I'm happy to bounce them by staff as need be, but if you don't mind, I'd appreciate if you kind of direct them to me and then I'll field them out.
Okay, that's my only concern about the ordinance. Okay, thank you.
Thank you, sir. All right, Ms. Dabo. And remind me before I start your clock here, because this is just a question I have for you. You were with Army Corps before, were you not?
Yes, I've been with the Army Corps of Engineers and the Florida Department of Environmental Protection, each 13 years each. And
all right, thank you. I apologize. I just didn't want to take it out of your time.
Thank you. Tammy Dabu, 170 Grant Road, Merritt Island. I'm in favor, of course, of this ordinance. It's long overdue. We need something to add some protection, especially from a compensating storage to North Merritt Island. And technically, it should be in all of Brevard County. It would have been prudent on the prior thing that you all were thinking about, the stem wall versus footers. It's distinct difference, but from compensating storage. This is what North Merritt Island is going through. It would have been what the development at elevation 2 would be putting the adjacent people in. So just perspective. But going back to North Merritt Island, I'm in favor of this. The only thing I had a concern about is throughout the ordinance, oddly, and I didn't notice it until I was reading it earlier tonight while I had time to sit here again, is that the ordinance specifically states that it starts from Hall Road and goes north. Well, technically, North Merritt Island starts from the Barge Canal, which is a little bit south, and goes north. So I'm not sure why it was worded like that, but at the very least, it should reference maybe Barge Canal north or Smith Grant Road north or something like that, something to think about.
Sure, and I can address that a little bit, and if Mr. Denningoff wants to jump in, he's certainly welcome to as well, but I know that we had spoken, Mr. Denningoff and I, when this was being initially drafted, as to where would be an appropriate demarcation point, and it was simply decided administratively on the staff side that that would be an appropriate point. I'm not saying that it might not be beneficial elsewhere, but the concern that I have at this juncture, and I'll ask Ms. Bentley as well, is I believe that it would require re-advertisement were we to expand the scope to include an area south of Hall Road. So I'm not opposed to that if we end up going to that in the future, but I think at this point, to get protections in place as quickly as possible for the area that's been identified, which encompasses substantially all of Merritt Island. It's not everything by any means. I agree with you 100%. I don't think there's a debate as to that. But I think given where we're at with what's been put forward, I'd like to move forward with what we have and see how it goes, because the other thing is when we end up next year in a position where we do have that drainage model back, we may have so much more information that enables us to move things, really to tweak them to almost a degree of perfection that we just don't have now. So I'm happy to revisit it next year when we have that model back. I'm just telling you, I'll meet with you. I'll go up to north of the Barge Canal, which I look at from the office every day anyway, or you can come down just south of it by a stone's throw. I'll sit down with you and we can go over what's appropriate at that point once we have more data.
Okay, great.
Thank you.
Thank
Yes,
you all
ma'am.
for your time.
All right, Mr. Bernardo. Good to see you, sir.
Thanks. Okay, again, I'm Phil Bernardo. I live at 4440 North Tropical Trail. I'm also Vice President of the North Merritt Island HOA. And to begin, I do appreciate the board's continued concern and interest in addressing our flooding problems on North Merritt Island. Its growth has been a real issue. As you know, land's being developed at a never increasing rate. Increased density comes with that, and all of that is adding to the flooding problems. It's getting progressively worse. So I support the proposed, amendments to the ordinance. I think it should be approved without exception. And I also think it should be done without delay, because this is a problem that's continuing to get worse at an ever increased rate. I like what Ms. DeBoo just said. I'd noticed that too when I read it, that I said, gee, it goes Hall Road north. And I know Smith Road, which is just over the Barge Canal, it does flood periodically. I think that should be looked at as well. I think there's a proposed development behind the Moose Lodge there. So it is something in the future to look at, but I'd rather not delay that. I agree. I think let's look at it in the very near future, but for now, I say let's go forward with what's being proposed.
Thank you, sir.
You're welcome.
All right, Ms. Hund.
Good evening. I'm Darlene Hunt, 125 West Chrysophilia Road, North Merritt Island, and this is the second time that we're going forward with this ordinance. So you passed it the last time, and so I'm just respectfully requesting that you approve this proposed ordinance to require both compensatory storage and certification by engineer, that there be no adverse impacts due to development changes to land on North Merritt Island from the area that you've outlined. And water tables have been rising on our barrier island, and that we need to do everything we can collectively for the residents and the future residents that'll help with their quality of life in Brevard County. I noticed in the paper this morning that there was reference made to beach management, a beach management article about rising sea levels, and we definitely are experiencing them on North Merritt Island. Thank you again for your support for this wetlands protection.
Thank you, ma'am. And last but not least, Mr. Botto.
Good evening. I'm still David Botto. I live in Indian Harbor Beach, and I serve on the board of the Marine Resources Council. We're very encouraged by this ordinance change that you're dealing with, and I understand its intention was to strengthen wetland protections in North Merritt Island so that new and redevelopment does not adversely impact private property, federal lands, and Brevard's waterways. We try to track these kind of changes because they're progress. And as we all know, there's a lot of old rules and current regulations that are outdated and do not protect our waterways the way they need to, that need to be changed. But I hit one sentence that made the red flags come up and the klaxon go off, and I just need clarification. And I'll quote it to you. It's in section 62-3723, subset 4. And I quote, let me back up. The movement for strengthening depends considerably on what's called compensatory storage, which is actually a very good idea. But this says, properties demonstrating discharge of runoff directly to the Indian River Lagoon are exempt from compensatory storage requirement. Of course, we don't think that's a good idea, that there's nothing to be done to prevent discharge directly to the Indian River Lagoon of runoff. Our hope is to prevent any discharge to the lagoon from runoff. So if I could get clarification of that, on why that's in there.
I'm happy to address that if you'd like.
Say again?
I'm happy to address that if you'd like, because I am familiar with that, having spoken with Mr. Denninghoff about it. Basically, this isn't creating an additional right over what exists now to have that sort of runoff. The purpose of this particular ordinance is almost exclusively, if not exclusively, to address flooding. So water quality issues, while they're important, they're not contemplated by this particular ordinance or the changes to this particular ordinance. So if there is something that's proposed in the future, I certainly would consider it, but that's not doing anything to worsen or to better water quality insofar as that section is concerned, but it simply wasn't the goal of this particular ordinance.
So the answer is there's really no change to existing.
As to direct runoff, that's correct.
Right. Thank you.
Yes, sir. All right, that's all the cards that we have. I do have a note. I spoke with Ms. Bentley earlier and also staff in P&D with respect to this, because there was a question that had come up to my office that I wasn't absolutely certain as to the answer. And I do want to share this with everyone just so that we're all on the same page. Those who've already had their pre-app meeting will be grandfathered in based upon the date of their pre-app meeting. So that means that if, depending upon that date, they may fall under the new or they may fall under the old. But once we pass this, anyone that's not already had a pre-app at that point will fall under the new. Is that a good kind of nuts and bolts summary, Ms. Bentley?
Yes.
Perfect. So with that, I'd love to have a motion if I could. Make a motion to approve it. All right, we have a motion from Commissioner Pritchett, second from Commissioner Smith. All in favor? Aye. Any opposed? Passes unanimously. Thank you all for coming, and thank you for being so patient today. All right, moving right along, J1. Unless Ms. Bentley insists that we have something read into the record, I'll entertain a motion to approve this request for an executive session in case number 14, Charlie Alpha 41947.
Make a motion.
All right, motion from Commissioner Pritchett, second from Commissioner Smith. All in favor? Aye. Any opposed? All right, passes unanimously. We don't have any, well, we do have one public comment. I apologize, Ms. Sullivan. I included you earlier, and I almost excluded you now. And Ms. Sullivan, you're in South Patrick Shores.
Sandra Sullivan, South Patrick Shores. I've never been to a county zoning meeting, so I hope I get things right. The reason I'm here tonight is a little bit of history. So the Brevard County purchased Hightower Park back in 1993 for $180,000. And then in 1999, there was an agreement reached as a co-applicant with the city of Satellite Beach to create a oceanside wildlife and habitat preserve to help protect endangered species, most notably endangered and threatened sea turtles. That area of beach is the highest aggregate loggerhead turtle nesting in the world. The reason it was chosen by the state to invest $8.5 million into a preserve with state funds was because Satellite Beach area had 87 percentile in terms of population density out of 401 municipalities. So the state funded the acquisition of lands with the P2000 grant. The Hightower Park in 2012 was put in the city's name. What I would like to know is, it says it says any to be used solely as a public beach park and any purposes providing public blah, 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 blah. Anyway, so the definition of public beach park and being used as by the public, a Oxford dictionary says that's an ordinary person. So to be used by a hotel as a corporate entity with a skyway over to that park, I would like a clarification if that would be permitted under, as being, its use being public, to open to the public. Can I pause my time?
Sure. Yeah, I'm not going to force Ms. Bentley to opine as to something, but if one of the commissioners would like to ask her, I certainly would not have any issue with them doing that. But I don't know if this is something perhaps they'd prefer to look into,
okay, and
then make a decision at some point in the future.
Okay, so then the other aspect that I wanted to discuss is that as co-applicants in the P2000 grant, there was terminology in there that says that the adjacent lands were restricted in height to the comprehensive plan that was amended at that time. And we would like to request the council's help in ensuring that agreement is enforced, given the intent of the state.
I'll just chime in as diplomatically and carefully as I can with respect to this. I have nothing but respect for the concerns that you've brought up with respect to that particular municipality. But there's a fine line, pardon me, sorry, I don't know if it's beeping at me or beeping at you. There's a line to be threaded with respect to that concern where we remain respectful of the autonomy of those municipalities. And I'm still trying to grapple with exactly where that line is. So I have not, and I saw that, I believe it was earlier today, that there was a call to my office from you. I've not yet had a chance to sit down and think about it with this meeting having occurred tonight or occurring at this point. But I'm happy to speak with you about that because I think you do raise some good points. I'm not saying that they're legally wonderful or legally terrible. I have not delved into it at this point, but I'm happy to talk with you after I have a chance to look at it over this weekend.
Okay, thank you very much for your time and consideration. And just to be clear, I'm really not talking about the municipality, but enforcing the preserve agreement that was, that the county and that other entity entered into to ensure that that agreement is met.
Yeah, just real briefly on that, I think, I respect that, but I think the two are inextricably intertwined, so it's tough to, and I respect that, but I think they're tied together so tightly. It's not really possible to view that without addressing the municipality in some substantial way. But
understood.
We can sit and talk about that later.
All right, thank you.
Thank you. Yeah, and then Commissioner Pritchett suggested it may be something that you'd like to address with Satellite Beach directly, and certainly I'm not telling you to or not to do that, but that's another possibility as well. But I'm happy to speak with you about it.
Can I just say one thing?
If it's something that applies to the whole commission, and very, very briefly, otherwise I'm happy to speak with you after.
I've exhausted everything in that avenue.
All right. Thank you, ma'am. Okay, so that's all we have with respect to cards for public comment. Board reports, Mr. Bate?
I don't have a board report.
Ms. Bentley?
No report.
Commissioner Pritchett? All right, I've got a couple things. I'm going to check with Ms. Bentley if one of them is permissible to discuss. Don't worry, I see that she's she's getting a little nervous. So the easy one first. We did address in item J as in Juliet 1 the executive session request. We're going to have another executive session request coming up. And I don't want to discuss too much at this point in time, apart from saying that individually all of us really should meet with legal to discuss an upcoming executive session request. I don't think it would be in the county's interest or in our fiduciary, in keeping with our fiduciary duty, to discuss why that needs to be discussed individually, but suffice it to say, I've not asked anyone to do that in the year that I've been on the commission. I think it's imperative that we each individually have a conversation with Ms. Bentley or with a designee of hers on that upcoming executive session request. With Ms. Bentley.
Would she please make arrangements to meet with us?
Would you, ma'am?
Will
Okay,
do.
so Ms. Bentley will go ahead and make arrangements to meet with the individual commissioners. And the other question, Ms. Bentley, and if you say this is verboten, then I won't touch it, but there's an item that's on this Tuesday's agenda I wanted to make a brief comment on this evening in board reports. If you don't think that's appropriate, I'll hold off and wait till Tuesday, though.
Been waiting till Tuesday.
All right, perfect. That's all I have.
don't-
Okay, no, in an abundance of caution, I'll wait till Tuesday. Commissioner Tabaya?
No report, Mr. Chair.
It's the third time. Third time. That's okay. I'll give you a pass. Commissioner Smith?
Yeah, I'll be brief. I have need for some appointments, and several of you have mentioned in the past that you have lots of folks that have been willing to volunteer for appointments. So if you guys could reach out to me or my staff, I'd be happy to hear from you.
Just in general, can you tell us?
P&Z primarily.
Okay, because I'm just thinking with Sunshine, if you tell us what committees they are, we can certainly, I can put something on the agenda, or we can figure out a way to do this at a publicly noticed meeting, but I'll take a look at P&Z.
Might have an extra little fella, too.
Okay, good. That's all I've got.
That is brief. All right, and Commissioner Isnardi unfortunately had to take off, so that's all we have. Unless there's any further business, we're going to go ahead and adjourn at 7:32. Thank you all for waiting.
The opinions expressed by any member of the public during any period of public comment do not necessarily reflect the views or opinions of the Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, or the program sponsor, and are solely those of the presenter. The Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, and the program sponsor hereby expressly disclaim any and all responsibility or liability for any defamatory or slanderous statements expressed by any member of the public during any such period.